Good morning. It's Wednesday, February 25th. We're here for the Franklin County Commissioners' Weekly Meeting. At this time, I will call the meeting to order and ask that you join me for the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Adoption of current agenda. Is there any additions or corrections?
Mr. Chairman, I move that we adopt the current agenda as presented.
I would second with one adjustment. We need to add an item to consent. Maker of the motion, would you be okay if I amended?
Yeah, go ahead and amend it. We'll have discussion.
Okay, so need to add an item number 9 to consent, Resolution 2026-086. And that resolution is to fix a Scribner's error in Resolution 2026-049.
Discussion?
The Scribner error.
It's just a Scribner's error, but making sure we do it right.
A correction, yep, I understand. That's fine. But what is the Scribner error?
I don't know. It was the way that it's written out. It's in the packet here on item number 9.
Okay. All righty.
Having a motion and a second, all in favor signify by saying aye.
Aye.
Aye. Public comment. Is there anyone in the room for public comment? If so, please come forward, state your name, and you have 3 minutes.
Respectfully, gentlemen, last week I let you know that I would come to redress grievances constitutionally, as is my right, and I understand things have been sent to correspondence. I understand there's great shock and awe that this is not legal, but what I am proposing is a coalition to hear why it is. And if you look at what's going on in our current legislation, they are violating our Washington State Constitution. Article Election Section 5 says that the legislature shall provide in uniformity of application and general laws and terms an election for county commissioners, sheriffs, prosecutors, clerks, even right down to precinct committee officers. So if they can pick and choose, they've already violated that Constitution. That's the guardrails of the law, the supreme law in this state. They're trying to do an income tax. Both of those require an amendment to the Washington State Constitution, which they can't pass. And then they're going to call you, the county electeds, to violate your oath of office by administering it as an extension of the state. But there are greater grievances even than that. And I have mentioned that we have been invaded. That's what this document is about. Now, if you'd like another week, I will concede, but I do have a constitutional right to redress grievances by petition under Amendment 1 of the U.S. Constitution, which is the supreme law of the land. And I do not wish this to be contentious. I wish this to empower and to bring the citizens and we the people who consent to the governed the voice that they need, and you are our first representatives. Thank you.
Anyone else in the room for public comment? Anyone on the phone? Hearing, seeing none. Approval of consent agenda.
Mr. Chairman, I move for approval of consent agenda items 1 through 9 as presented.
I second.
A motion and a second. Is there any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Aye. Motion passes unanimously. Regular business, Resolution 2026-085, Benton Franklin County Superior Court. Presented by Jacqueline Stam, Judge Brown, and Judge Ruff. Superior Court judges. Good morning.
Good morning. So thank you very much for allowing us the opportunity to present to you today. I submitted a request for the Franklin County Board of County Commissioners to amend their 2026 budget to adopt a funding resource for the court to establish and create a Franklin County Juvenile Court. We understand, per the agreements between Benton and Franklin counties, that as of April 1, 2026, the entity of the Benton-Franklin Juvenile Justice Center will no longer exist. So that means that Franklin County will be responsible for providing resources to the court to create a Franklin County Juvenile Court. In my discussions with some state people this week, I was told that this hasn't been done since 1986. There hasn't been a new Superior Court establishment in the last 50 years or thereabouts. So it's something new for a lot of people. Per my letter to the county commissioners in February 9th, we have approximately right now 53 youth in various stages of dependency proceedings. That's where youth are taken away from their families. We have approximately 162 cases in offender supervision, criminal supervision, and we have 304 cases in truancy, diversion, and at-risk youth. So those cases will now need to be heard here in Franklin County, not at the Juvenile Justice Center. By separating the bi-county judicial district, a court will no longer, Franklin County Juvenile Court will no longer be at the center on Canal Street. It'll be here and upstairs in our Superior Court. This budget that I've requested, or that the court is requesting, I just want to make sure we understand a couple things. It doesn't include any funding for judicial officers. That is something that's paid for through the Superior Court judicial officers. It doesn't include funding for a juvenile work crew. Our priority right now is establishing a court so that we have jurisdiction over these cases, and we may be back here in the future to ask for funding for a juvenile work crew. It does not include funding for the ITC, or the drug court, the individual treatment court. We currently have 6 Franklin County youth participating in our drug court, ITC court, and I will be asking during my presentation if we can have funding for that, for those youth to remain in the court. So our budget does include the following requests, and I think I tried to outline that in our packet. It includes a request for 7 employees. It includes a request for a juvenile court administrator. That person would be responsible for conducting business, getting contracts signed, doing the finances, communicating with the board about signature of contracts, entering into new contracts, supervising employees, managing the budget, all the requirements of an administrator. It will include funding for 4 juvenile probation counselors. Those counselors would probably be, they will be cross-trained to do all the offender, all the civil, all the guardian ad litem requirements. It includes funding for 2 legal process unit employees. Those employees are very important to the assistance of running an effective court. They do all the paperwork to schedule hearings, to communicate with the citizens about court dates, about effective data entry into the state system, so that the grants that are applied for has the data and the backup for that request for grants. So we are asking for 7 employees. Part of my budget package included the spreadsheet that shows the cost of those employees is just over $800,000. The request for another $330,000, I believe, is for programs, counselors that currently, or that when it separates, the entity no longer exists. So all the contracts that we have are going to have to be re-entered into, one with Franklin County and another one with Benton County for the services for youth. So contracts such as for CETA, that is a detention alternative, chemical dependency detention alternative, contracts with functional family therapy counselors, contracts with employment education training counselors, interpreter services. These are all things that we need, an interpreter for sure, to run court, but these are probation services that we're asking to fund. You'll note that we're not asking for funding for selective aggressive probation. That is not an evidence-based program, so we removed that, even though we had those numbers that I prepared. I think I tried to explain. I received from requests that we made for the 2026 budget, Franklin County share of those services and those programs. So I'm not asking for anything more than what Franklin County's already been providing as their share of their 35% share of payment for the Juvenile Justice Center, the Bi-County Center. So it's, there's a lot of things that have to happen. We're 35 days out from starting up a new court. There's a lot of details that need to occur. So we're asking for this to be approved today because every day that we don't have a decision about what Franklin County's intentions are for the support of and the creation of a juvenile court just brings it into more chaos. If we don't have a court, then we don't need to worry about detention because we won't have a detention to have. So we need the court for the jurisdiction to process the cases, to give the families and the youth their access to justice. And so that's why we need to do this first step first and then work through all the details for this. This request does not include funding for detention. We understand that you've entered into a contract for detention. So we are asking for you to approve our budget request today. A couple of things I also wanted to make sure that was clear in my request because I think I said estimated some costs. The page 2 or attachment B, I indicated that we're asking for monies for a school liaison program. That's a partnership that we have with Franklin County, or with Pasco School District. That agreement is entered into every year. That expires at the end of the school year. It'll be renegotiated, and so that is going to be dependent upon Pasco School District participation, wanting to enter into that type of contract. The Franklin County Juvenile Drug Court, that's the ITC court I was asking about. I am requesting funding to support the youth that are currently involved in I keep saying drug court, but it's ITC court. In ITC court until they graduate. Right now we have 6 participants. Hopefully all will graduate by the end of the year. There's no promises about that. That's paid per participant. And then the startup for laptops training, that's just an estimated. It's estimated. I just estimated that. So do you have any questions for either myself or my colleagues who are here today?
Questions?
Sure, thank you for the presentation. I'm trying to get up to speed on this as I haven't been involved in any of the conversations. All I have had is the reading of the letters that have gone back and forth, although I think meeting in person is much more helpful and productive. In a couple of the correspondence that you provided to us, for instance, the letter dated January the 30th of 2026, it says the Benton and Franklin Superior Court has not and will not delegate its authority to operate juvenile court. So with that question, and then I haven't been able to put my fingers on it, but in a different correspondence, you articulate that this is a core function of the Superior Court. So in light of that, it would be my assumption that this money is already within your budget. And if it is not, is somebody giving you money to run these operations out of their budget?
So it's not a core budgetary function of the adult Superior Court. We've always come to you with 2 presentations. One for adult Superior Court, which is the judges and the people to run court for Superior Court, and we've always come to you for a juvenile budget request because that's a separate, totally funding system. So no, we do not have the ability in our Superior Court budget to operate a juvenile court. That has always come in 2 separate budget requests since we've had juvenile court.
And so I'm unaware that we cut anything, any budget, with the exception of juvenile detention, or unless somebody can explain it to me better, where they lay their head on a pillow at night. As far as I'm aware, we have asked for, from what this Board of County Commissioners has been working on, and then, as I said, I'm trying to get up to speed with what you guys are now trying to do. It appears to me and from everything that I've been able to research and everybody that I've been able to talk to, as I've not been able to talk to you, that you guys are attempting to do what it appears to me is a legislative action that has to happen in Olympia. Is there somewhere that I'm misunderstanding that?
So the statute that has a bi-county judicial district, that statute addresses 7 judges. The juvenile court has been operating under agreements between the Benton County Board of Commissioners and the Franklin County Board of Commissioners since 1953. So every year, the parties enter into an agreement to operate and fund juvenile court. And now that agreement has been terminated. So now we're coming to you because there's going to be a separate Benton County court and there's going to be a separate Franklin County court. So did I answer that question for you, or is there?
It does not.
Okay.
As from everything that I've been able to understand, the bifurcation of a bi-county court system has to be a legislative action from Olympia, and I'm unaware of anything having happened over there.
Sure, we're not asking to separate the judges. The judges will still remain bi-county, and the court commissioners will still remain bi-county. So the presiding of the court cases will still be the 7 judges and the 5 court commissioners that we have. So we are not asking to bifurcate. But the agreements for juvenile court, because of the agreements that you've reached, they no longer exist. So
Please, if you will,
Yeah.
help me understand.
Judge Stam, in my letter to you, I had indicated that, and I think I sent a copy, and I think Judge Brown, you were copied on that too. The way that went was Benton County drafted a CR2A agreement, sent it over, we signed it unchanged, sent it back, and they didn't sign it, so we don't have an agreement right now.
Okay.
So, and then after that, they made a counter offer to their own original offer, which I indicated in the email to you all. So we're pretty confused at this point because their offer says things that conflict with what you are saying in the administration of certain services. And I think that's where the commissioners
Okay.
is probably, I think that needed to be added to the.
So, and Mr. Dancel, I agree with you. Looking at the agreements going back and forth, right now, technically, the interlocal agreement between Benton County and Franklin County isn't terminated because the way, there's no agreement. It looks like you're right, it looks like Benton County proposed an agreement, Franklin County signed it, Benton County didn't sign it, and then sent over another agreement. And so at this point, there isn't an agreement, and therefore the interlocal agreement is still in place. What Superior Court is worried about is, like Judge Stam said, since 1953, there's been interlocal agreements between both counties to fund juvenile court. And as all of you know, juvenile court is, under statute, a division of Superior Court because there's different rules that apply. And so in the interlocal agreement between the counties, the funding wasn't just for detention, it was for all the juvenile court services. And so that is where the court, we're in a hard spot because we see the counties going back and forth. There's not an agreement, but it looks like the termination date is going to be the end of March. And where we're at is, unless something happens really quickly, we're afraid that the juvenile court there may not be a juvenile court in Franklin County. If there's not, it makes it impossible to bring juvenile offenders to justice. And then that creates chaos. And I know no one wants that, but I don't know, it seems like Benton County's understanding things differently than Franklin County, and we are in the middle. We just need to operate a court. We can't operate a court without funding.
But, so Mike, they offered the agreement, we accepted their terms, and then some conversation or something happened to where that became not good enough. And I just I'm wondering what the.
We can't comment on your pending litigation. All we're here to tell you is that we're caught in the middle. We have always come to you for money, and that's what we're here for. If the intention of Franklin County is to ultimately set up its own juvenile court under the umbrella of Superior Court, then we need money to do so. Since 1953, you funded a building, you funded staff, you funded programs, and you funded youth on parity between Benton and Franklin counties, and youth have benefited from the expertise from the one-stop shop that the Benton County Juvenile Justice Facility in Kennewick has offered. If it's your intention to set up your own juvenile court, we're here to tell you what we need in order to make a bare bones Franklin County Juvenile Court work. And we just need you to know what we need so that when and if you do reach an agreement with Benton County to go your separate ways, you are able to immediately fund what we need. Because if you don't, if we don't have staff, if we have a building here that we're going to figure out a way to fit all those juvenile hearings into our 3 courtrooms upstairs, and we're going to find a place for the staff somewhere in this building where we're already bursting at the seams, we can do that. But if we don't have the staff to meet with the families, to process the paperwork, then you have families in Franklin County who are not going to be able to access justice when they're separated from their children, when their children are going through a criminal process, when their children are at-risk youth, when they're truant from schools. So that's what we're here for. We're not here to comment on your pending litigation. We are not parties to that, and it's inappropriate for us to do so. We're here to tell you what we need to offer Franklin County families and juveniles bare bones services to get a juvenile court up and running if that's your intention to separate from Benton County. So that's what we're here to express to
And,
you.
Your Honor, I thought that the record needed to be cleared because Judge Stammen said we had reached an agreement, and we hadn't. I think that factually being correct is important, so that's all I was going after.
Mr.
But
Chairman?
Thank you.
Yes, Chair recognizes Commissioner Didier.
And I believe we can't move forward with granting anyone, we can't double pay on this situation. We need an agreement with Benton County. So you need to meet with Benton County and find out what's the hangup here. You need to ask them, why haven't you signed that agreement that you sent over? Secondly, I would like to know, what is the amount of grant funding? We're not privy to any of this information. How much grant funding are you getting?
So in the spreadsheet, and it's at least from what it's
Attachment B, page 2. It is outlined, the amount, the program name, the total cost, the grant is received, the local contribution, then it's broken out Benton County and Franklin County. So that shows the grant money that's received, and then we reduce the total amount, and Benton County has their share, Franklin County has their share. So I tried to provide that information
And
to you.
we have Gordon Thomason here, who is the administrator for juvenile court, that I think can better answer that too.
Well, it is broken out accurately, but based on how the programs are set up, is we've heard from you guys that you want to streamline and make things different than what they are right now. There will be some adjustments based on what directions we have, because the state will give funding based on how many programs you're willing to fund. So you put some money in and fund certain programs, they'll up the amount of money. If you say we're not going to be funding any of these certain programs, the state won't give you any money for those programs. So it's a pay-to-play type thing.
Thank you.
So who is signing up for grants on behalf of the Franklin County Board of Commissioners?
Currently, it would be, we are signing up as a team. So the juvenile justice.
So the Benton Franklin Juvenile Justice Center is entering into grants on behalf of the Franklin County Board of Commissioners.
We have been, yes, with your guys' signatures. You guys approve all of them. So we do the legwork, and then you guys have approved them in years past.
Okay. I'm trying to find it here. Brian, you might be able to help me. In one of our correspondence back to one of your letters, we described what we were trying to do, and in a nutshell, without put my finger on it, we are simply wanting to change the location that they lay their head on a pillow at night, because that is significantly less expensive for us. And with the budget constraints that we have, that's where that came from. And so I've heard presented that we are trying to bifurcate the juvenile court, and I've never heard that conversation having happened ever once. It certainly has never happened with me, and so I don't understand how we got to this point where that we've been funding the juvenile courts, and we haven't adjusted that. We simply are changing juvenile detention services from one facility to a different facility. So can you help me understand where that something that we've already funded, now we need to fund north of $1 million in addition?
Yeah, so I would encourage the counties to talk, because where we get our funding for juvenile court is through the interlocal agreement between Benton and Franklin County. So the payment you make to that interlocal agreement funds the juvenile court staff and services. And so that's what we understand is the county's wanting to terminate. Now, if there isn't, it sounds like there may not be understanding of what those services are provided under that agreement. We'd encourage the counties to talk, because we are just left in the middle of trying to operate a court, and we need funds to operate the court.
If I could add something, Commissioners?
Yes.
I think part of or one of the challenges that we're facing here is we're kind of caught between the parties as well. We have, the judge is telling us we cannot, administer probation and court services, that it's a core function. And then we have Benton County offering as a settlement to terminate certain probation programs, which we can't do. We can't agree to terminate programs that we don't even administer. So it's almost creating a situation where we all kind of have to come together and figure out what services does the court want, and what services is the court okay with us terminating, because we don't want to invade the court's authority under these statutes to administer probation and court services.
Well, that's, I think, why we're here today, right?
Right.
Because the services that have been jointly provided through the Benton Franklin County Justice Center are all going to be terminated because that entity is not going to exist. So we're here today to say, these are the programs that we believe, that we are asking for Franklin County to support the youth. And we will be doing the same with Benton County when the time is appropriate with Benton County. So I don't think that you're invading our purview at all by, these are kind of, I think what it is the details of the
Right.
settlement agreement. So now we have a general, I shouldn't be commenting
Okay.
on the,
Sorry, I know how these are all interrelated.
Well, and one thing I continue to hear some confusion about is this pushback that the court has said, we the court are not willing to delegate probation services to you, Franklin County. And what we mean by that is probation services, juvenile court is under the umbrella of a separate branch of government, which is our Superior Court. We administer that. I think we've worked past this issue, but there was an issue a couple of months ago where it appeared Franklin County commissioners were attempting to take over and administer probation. So when we say we are not willing to delegate that from Superior Court, what we simply mean is, as you have done for the last 70 years, you give us the funding and we hire the staff to administer probation services, as we've done for 70 plus years. So maybe we're misusing some pronouns when we say we and you. Probation services will remain under the auspices of the court, but as always, we need funding from you to fund those positions. So if you choose not to fund our branch, then we can't do anything. We've put together our proposal for the staff that we need to administer probation, guardian ad litems, legal processing units. So we are not delegating our authority for juvenile court probation, services or administration to you, the executive branch. We're asking for money, like we do every year at budget time. So there is nothing different about it. That's what we wanted to make clear, and I think Commissioner Baumann, you referenced a January letter that had to do with a staff person that was hired to do services that were not yours to hire that person to do. I think we've worked past that issue, and I appreciate the meeting. I think we had a great meeting with Mr. Danzel and Commissioner Didier working through that issue. So it's not an issue anymore, but I hear that it still may be creating some confusion. So that's what we mean when we say we are not delegating that. We are not. And we're not asking you to. Our budget asks you to fund the essential personnel to run this court if it were to be separated from Benton County. And I understand you're still in the middle of litigation, so that's what we're here for. So I hope that kind of clears up some confusion. We are here to do our job, which the law tells us very clearly what we have authority over, and we want to do that. We want to continue doing that seamlessly for residents of Franklin County, and that's where you come in.
And just a follow-up question on that, do you believe, to sort of parrot, I guess, Commissioner Bauman's concern, do you believe that we have the authority to agree to separate? I keep hearing that we're going to operate our own juvenile court. I know that we can be delegated authority under 1304-035 to administer it, but the court is retaining that jurisdiction. They're not giving that to us. And so RCW 1304-021 indicates that the juvenile court shall be a division of the Superior Court. So can we really, in a bi-county system, have two separate juvenile courts, or are we going to run into some sort of attack on judgment saying the court never had jurisdiction over these cases?
You have pending litigation on that, and so far the court is not a party to that litigation. So that's all I can say on that.
Your Honor, I appreciate
Oh,
the
can I just add
acknowledgement.
one thing? We will be litigating Franklin County youth inside the jurisdiction of Franklin County. So I don't know, I just want to make that clear. We're not asking to litigate Franklin County youth anywhere other but inside Franklin County. So, I'm sorry, Commissioner Bauman.
Your Honor, I appreciate acknowledging that there are two separate branches of government here at work. And I was reading verbatim, the Benton and Franklin Superior Court has not and will not delegate its authority to operate juvenile court. As I'm trying to come up to speed with this because we've laid it out pretty clear in our communication that we are simply adjusting juvenile detention. We have not, in any way that I am aware of, ever said any of the other things are we weighing into or asking you to change. The juvenile court, you are a bi-county court. It clearly says in the RCW that the juvenile court is a subdivision or a part of the Superior Court, and we are not asking, as far as I am aware, that any of that be changed. And so, being a core function of your court, my question would be at this point is the monies that you're asking for, is it currently in somebody else's budget that they're not going to give to you for the continuation as is of the court system as it currently operates? Is there a reason we can't continue on as we currently operate the juvenile courts?
I think that's where the misunderstanding is. So our funding for juvenile court comes jointly from Benton County and Franklin County through that interlocal agreement. So Franklin County pays a certain amount every month, which covers juvenile detention and juvenile court services. Benton County also pays a portion for those services. And maybe that's where the disconnect is and where the counties need to talk, maybe, and we're left in the middle. But from what we're hearing, the intent was Franklin County just wanted to separate the detention. They wanted everything else. Well, if that's the case, encourage the counties to talk, because obviously it'll be a lot easier. We understand that the counties may want to go to the legislature to split the judicial district. But trying to operate two courts and the judicial district not separating, you're now seeing the complications of that.
Well, I guess I'm even further confused now. Does the Superior Court need Benton County's permission to continue to operate the Superior Court in a Superior Court and a juvenile court system?
Well, they're not going to fund the 35% of cost that Franklin County's been paying to operate juvenile court, because I think what they understand, what the court is understanding is that agreement is what the counties are negotiating to terminate. And so if that's terminated, Franklin County's payment for those services goes away. That's why we're here asking you for funding to operate the court in Franklin County.
It would be up to you, Mr. Chairman, to recognize it if you want to.
Clarification.
Chair recognizes Gordon
No,
Thompson.
apologize about that. So we came to you in October, end of October, I believe, or the first part of November with our budget. And it was a total of $2.9 million. That was detention and the administration funds. And I believe it was 1.4 was detention, 1.5 of that breakdown was on the administration, probation, the civil division of what we're talking about today. Those numbers were exactly the same of what you guys funded the year before. So it was just 2.9 the year before, and we just were doing exactly the same thing. Come December, when Franklin County put out their financial information, that 2.9 million section that was in there the year before was wiped out. In a different area, there was a notation of juvenile justice, $500,000. So when you get that paperwork and it shows that there is $2.4 million that have been removed, that is in a sense telling us that we're being unfunded. And what I hear you today saying that, no, we're not unfunding, we just want to do Martin Hall. But Martin Hall with $500,000 doesn't fund the administrative portion of the courts.
I'm trying to understand why that a essential core function of the Superior Court would have an essential part of their budget within a different organization's budget. And if it's a core function that you cannot and will not delegate to anybody else, are you an employee of the Superior Court, or are you an employee of Benton County?
I'm a bi-county employee, Benton of the Superior Court Judge.
So you're an employee of Benton County, and you administer this operation on behalf of the court. It has been delegated to an employee of, as you describe it, as a bi-county, and so it has been delegated to you to operate this system. Am I not understanding something accurately?
I'm understanding I'm a bi-county employee, which is Benton Franklin.
Please.
My understanding, and I don't know a lot, obviously, but is that they are Benton County employees because they fall under Benton County benefits. They went through the Benton County HR system. We have no right, you correct me if I'm wrong, to train, supervise, make any kind of recommendations on anything.
This is definitely getting into the litigation stuff. I mean, it's kind of hard to steer clear of it given what we're talking about, but
It's a gray area, though.
that's why I wouldn't want to comment on it.
Mr. Danzel, your attorneys from Franklin County were in the negotiations for salaries. They wouldn't be in there if they were only Benton County employees. It's a bi-county
Franklin County
negotiation.
has signed off on all the collective bargaining agreements up until this year for the joint bi-county juvenile justice employees. And just
I
to,
recognize Commissioner Didier.
Plain and simple, 2.9 million, I'm a numbers guy, 500,000 for detention, 1.129,973,000 equals 1,629,973. We stand to save 1.3 million. Why are we being charged 2.9 million?
Well, I'll share with you, because you're no longer going to be paying the detention services and the employees that are involved with detention services. You're no longer paying for facilities. You're no longer paying for the employees that are involved with facilities. So there are many things that you will not be responsible for by what we're talking about today.
And what we're trying to do here in Franklin County is we're trying to be very stringent on the taxpayer dollar. And if we can save 1.3 million, I think we do it. We just need Benton County to sign off on the agreement they sent us. That's all we need. And until then, we can't sign anything with the Superior Court judges because we'd be double charging ourselves.
I find myself in is I would love to meet with the judges and talk about, we were going to look at where we were going to put people and everything, but when we don't have an agreement in place, and I don't know how you talk with one about the other, so it's very difficult.
Well,
because
it sounds like the judges are saying it's okay to talk about these programs that Benton County is, in their updated offer, has proposed cutting. They're just wanting to know whether or not they can have the funds to fund the programs that they're presenting to us today with their budget presentation, which does not include those programs.
No, I'm well aware. But I still think that it's, how can we agree to a funding request when we don't know what the agreement is? We signed an agreement that was sent to us by the county that filed the lawsuit, and then we accepted it, signed it, sent it back, it went unsigned, and now a new, so I don't know.
So we don't have an agreement.
Yeah.
That's pretty clear.
Do we know why that they haven't signed the agreement that they sent to us?
I think what our legal counsel is hinting at is that we should probably take all this into executive session.
Certainly a discussion of whether or not to sign a settlement agreement, an updated one, we'd want to discuss that privately.
I just want to close by saying we appreciate you hearing us out and having the opportunity to clarify any confusion. We appreciate you listening to us, because the sooner we can get funding for whatever we need to provide services to Franklin County, the better for the community and the better for the citizens. We are here to administer and provide access to justice. It takes money, as you know, and so I understand you're not in a position today to approve or deny the budget request, but I appreciate hearing us out, getting some clarification, so I think you have a better understanding of what we do in juvenile court, what we offer to the community, and what we will do our absolute best to continue to provide with continuity of service, given the time constraints that we may be under whenever or if ever there is an agreement between the counties. So we really appreciate this opportunity. I know we took a lot of your time, but hopefully it helped flesh out some confusion and issues.
Thank you.
All right, thank you. Commissioner Administrator updates, Mr. Danzel.
A thing from someone that's watching has said that right now there's no more sound, that they can't get sound on our YouTube. So we might check with that and see real quick. Do you want to maybe recess for a couple minutes until we figure the bug out?
Yeah, probably so.
Should we recess? All right, thank you.
So we'll recess for 5 minutes.
Thank you.
Who said that?
5-minute recess is over, so we will resume business at this time. Moving back into Commissioner Administrator updates with Mr. Danzel.
Thank you, Mr. Chairman. I'll keep this one short and to the point. We had a mediation meeting with one of the collective bargaining units. I met with the auditor's office staff, met with OPD. Larry Ziegler needs a meeting with you gentlemen to discuss some of the trends and also some of the budget line items when it comes to OPD. I met with you gentlemen regarding this upcoming agenda to get you prepared for it and all. And then I've had a full docket of out-of-area meetings and appointments that have taken me this week out of the area, but I wanted to keep it short and to the point because we've got a ton of correspondence that I wanted to get through. So that's my report for this week, but if you have anything to have me working on, just let me know.
Thank you. Commissioner Baumann.
Thank you, Mr. Chairman. I'm going to be fairly brief here. I spent 2 days last week over in Olympia with the Legislative Steering Committee of the State Association of Counties. You should each have a packet of some of the information that we brought back. The most specific thing is the packet that has the Office of Public Defense and some of the issues that WASAC is working on behalf of all counties. And then I got you some information about K-12 education and housing in our state. Also had a federal partners meeting in preparation for our Rural Prosperity Summit on March the 26th at the HAPO Center. Just thank you to everybody that's working so hard in preparation for that. Spent most of the day yesterday at our emergency management doing a exercise dress rehearsal for the Energy Northwest, the nuclear plant out there, and our local agencies and what we would do in the event of if any issue were to happen out there. Just thank you for all the hard work that is done and all of the agencies that are involved in that. And that's a FEMA exercise where that they come in and watch and take notes and ask questions and evaluate our preparedness. And so just a point of personal privilege, just want to say thank you for all those that know my mother had open heart surgery, and thank you for all the prayers that have gone up. She's doing well. Got to go spend some time with her again early this morning, and she is recovering well, so just thank you for everybody for that. And Mr. Chairman, that's my report.
Thank you. Commissioner Didier.
I did not know that about your mother, and I certainly will keep her in my prayers.
Thank you.
After our meeting last week, I met with Christopher Dahl of the Columbia Basin Veterans Center. Had a great discussion, and I'm scheduling another meeting with Mr. Danzel. I'd like to report that on May 1st, they have their banquet, and they still have 7 tables available, and this is honoring our veterans of the area. And he's doing an incredible job down there at the Veterans Center. They're in the black. They are actually making money. He's doing an incredible job. In speaking with him, I didn't realize he's not a veteran. He's a pastor, and a very good one at that. He is a good man, and he's doing a great job. This banquet will be held at the Michelle's Restaurant in Richland. There are still 7 tables available. I have put my name on one of the tables. I will be there, and I encourage us to fill that place up for our veterans. After that, the Board of Health meeting, where it was stated that they're doing a study on nitrates in the soil, and if every term that the word nitrate came out, farming came up in the same breath. And I have to keep saying that when my parents moved here in 55 and they drilled their well in 56 or 57, that well had such high nitrates they could not use the water for making baby formula. And our neighbors, the Wards, used the water of the Bureau camp to make baby formula, and yes, one of their children got the blue syndrome. There was no farming in the area at that time. So how can we blame nitrates on farming when the nitrates here was so high at that time that you couldn't use it for formula, why is farming the culprit for high nitrates? This is very disturbing. It's an attack on the farming industry, and we are already suffering hard enough right now. I had a wreck in front of my house this morning with the rains. We had ice in certain areas. A driver got caught off guard and actually wrecked right across from our house out in the field. Equipment now is moving down the roads. Show patience, please, because this equipment only can go so fast. We don't have any turnouts yet. We are pursuing that, we've got our federal partners coming in, and we're going to be talking to them about that, maybe trying to get some funds for creating turnouts for farm equipment to get off the road to let the cars go by. We are pursuing that, and we have restored all the money to the road department, and hopefully maybe we can even start using some of that. Had the agenda meeting, and I thank Mr. Danzel. He goes out of his way to make sure he meets with every commissioner. He drove out to the farm for me yesterday, and I really appreciate that. You bringing that out, going over the agenda with me. It saved me the time. Thank you very much. And the last is the VFW Post 5785 banquet, red, white, and blue banquet, honoring our veterans is going to be on September 19th of 26, and I'll reiterate that. I have a really good friend that's part of that, Big C Charlie Warren, who used to be a radio host, and he's a Vietnam vet. And I see we have our veteran in the back of the room, Mr. Dockstetter. Would you be my guest if I was to buy a table, you and your wife? I would love to have you sitting at my table at that banquet. So with that, that's the end of my report.
All right, thank you. Last week also had the Board of Health meeting, also good roads of Benton and Washington. They are going to reduce the speed limit north on 395 down to 65. Also this morning had Visit Tri-Cities meeting. Some interesting, very good news coming out of the HAPO Center. They had a 71% increase in events last year, a 52% increase in revenue, and 616 thousand and increase in sales revenue. So also had Tri-City Regional Chamber of Commerce meeting last week, and then also had some comments I wanted to ask my fellow commissioners about the transit. I heard that they're going to hire security to ride the buses. Is that true, or do you know anything about it?
I can answer that. Yes, they've already done that. We were given a report last year. CEO has been working on that. He described it in the December meeting. There was a three-phase process that has since been reduced to a two-phase process. So the first phase was security similar to what we would see out here in our guard shack that patrols the campus of the facilities and the administration and operations facility there. And then the second phase, which combined phases 2 and 3, is going to be roving security that will ride buses and be present at transit centers. It's not, they're not saying what the schedule is, but that there will be, on random buses, any given route, there may or may not be a security guard riding a bus.
Is there a need for this? Because I know the response times from local law enforcement are exceptional.
So they felt that there was a need in just to have the presence of security. It's not a lot. It's a small group that will go and be there. There's been some issues that leadership there at transit staff felt like that this might be a good first step in addressing some of those issues. And you're correct, we have some excellent law enforcement in our communities that do respond rapidly to those criminal elements. And at the next transit meeting, staff is going to give us a safety briefing, an update on our policies, what it looks like, how it works, what the policy says for staff to do in the event of a hostile rider, or and it'll describe the difference between criminal activity when you call 911 and whether it's somebody that's being obnoxious that needs to be trespassed.
Okay. From the amount of people I see riding the bus, I don't see that this is just another waste of money. And to point things out so the public is aware, we spend, of your sales tax, 0.6% goes to the transit. 1/10 of 1% goes to the recovery center for mental health. There's going to be a time where we need to reevaluate where we're spending our money. And I think this is a great example. We have one of the lowest rates of police officers to citizens in the country. We try to spend our money, the taxpayers' money, the best we can to get the best bang for the buck. And it's discouraging to see that we have such low numbers of police officers per citizens, and yet then we have an entity that drives around with empty buses hiring security. And our local police departments do an exceptional job whenever there's been an incident. It's time that we take a look at this and reevaluate where taxpayer dollars are going. Also, last week certified the election. So when you wonder about your tax bill when it comes for your property taxes, just want to let everybody know the county gets about 9 cents of every dollar that you pay. As an example, the school district gets over 75 cents, just to put that into perspective. Anyways, that concludes my report. For this
Mr.
week.
Chairman?
Yes.
I believe Mr. Bauman recognized this, and I have it on my list, and I forgot to mention it, but today HWL has a luncheon for first responders, for our police officers, for our firefighters, and for our EMTs. And I would encourage them all to get there and gather, and I would just want to say thank you to all of them for their service to our county and our country.
Absolutely, yes. Thank you for pointing that out, Commissioner Didier. There is, they are putting that on. Our contractor there is doing that at their own expense in appreciation to say thank you to our first responders.
Yes, thank you. Mr. Danzel, correspondence.
Thank you, Mr. Chairman, and I missed one thing, and I wanted to make sure for housekeeping. There is a county administrators conference the 1st through the 3rd of April, and I think it would be well if I went to that to stay in tune with everything. Now, if that's the worst April Fool's joke history in the history of mankind, then I'm not going to be pleased, but it's April 1st through 3rd that I'll be at that. So I wanted to bring to your attention First Amendment petition for redress of violations of the guarantee clause and the enumerated powers within the Constitution for the United States of America by Congress, as presented by Mrs. Andrews, and I want to pass this down to you. I've also given a copy to our prosecuting attorney's office, Counsel Briggs, to be able to consume this. There's quite a bit there. And so I just wanted to, this is the first correspondence that I could hand to you, and then it'll be up to you gentlemen. You tell me if you want me to schedule this for agenda time or what your thoughts are from there. The next letter that I have comes from the prosecuting attorney's office, and it regards positions that are approved in the budget but unfunded at this point. And really, I think more than anything, I would turn that over to Council Briggs if you feel comfortable with that.
Right, yeah, I can provide some input on that. So these positions actually are funded, so they're just not filled right now. And due to the hiring freeze, we're coming to the board to fill those positions. I believe we have 3 prosecuting attorney positions and then 4 support staff, 3 or 4 support staff. One of those support staff, I believe, is going to be making a lateral shift, and so we'll need to basically backfill her position. So we're asking to fill 4, but technically it'll only be, I think, on the support staff side, 3 new hires.
Mr. Chairman?
Yeah, the chair recognizes Commissioner Didier.
So, Mr. Briggs, on this, this is already in your budget.
Correct.
Obviously, so it's
Right.
there, and you just have not filled the positions.
Right.
Because, Mr. Danzel, we have already got a $460,000 hole blown in our budget from funding the juvenile justice for 2 months, and it looks like it's going to be a 3rd month. So we are taking a big swath at our budget already on trying to keep a balanced budget.
Yeah, it's the number's more than that actually, but I do.
It's lower than that?
It's more than that.
Oh, it's more than that.
Yeah, but I do support this request.
Yes.
I mean, it's absolutely critical. I mean, they're all on the criminal side.
Yep.
So it's, I mean, we don't really see it on our end because I'm interfacing on the civil side, but on the criminal side, we are down significant amount of deputies and support staff. And along with that, we have screenings that aren't being, I mean, and these are, in some instances, very serious felony matters that are just sitting, with the victims not having access to justice. So.
And that's why I was saying this is already in our budget, so this
Correct.
isn't going to hurt our budget at all, but we are suffering a budget shortfall already.
Any further correspondence?
We do. We have a lot more correspondence, Mr. Chairman. One of the most exciting pieces of correspondence is the piece that I received from Captain Jansky, who I don't see out in the audience today, but that we're on track to receive our reaccreditation at the jail here anytime now. So I thought I would provide that. I think that's a good look. I need to confer real quick with our lead. Finally, the piece of correspondence I have, and actually I'm going to ask you to take one of these and pass one down, is a offer from HWL to amend our current contract with them for the running of the HAPO Center. And so I know that it's been discussed off the cuff numerous times, but I think it kind of, pardon me here, it hits on some of the issues that have been sticking points under the current agreement. And I know also, I'm pretty sure that Mr. McCall's at least had the opportunity to meet with Commissioner Mullen and Commissioner Didier. I'm pretty certain that Commissioner Bauman's aware of this as well. But this is the official offer that they wanted me to present to you today. So my suggestion on this, gentlemen, is take this, think about it, kick it around, and then come back maybe next week and see what we think of it.
Good.
And then the only other stuff that I have would be proper for executive session.
All right.
And did the board want to make a decision on the prosecuting attorney's office request?
I am so sorry. So my apologies. Yes, you need to add an action item and then take action on that. And my apologies, Council Briggs.
Mr. Chairman, I move that we amend our agenda to add a potential action item to our agenda, and that action item would be action on the letter that we received from the prosecuting attorney's office.
I second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Aye. Motion passes unanimously.
Thank you, Mr. Chairman. And with that, I move that we accept and authorize the PA's office to fill these positions in the letter that we received and fulfill that request.
I second.
A motion and a second. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Aye. Motion passes. Moving on to public comment. Is there anyone in the room for public comment? If so, please come forward, state your name, and you have 3 minutes.
Hi, my name is Erin Petty, and I've had the privilege of corresponding with some of you already. I'm kind of piggyback on the judges that spoke today about the juvenile detention and the interlocal agreement that Franklin County is no longer a part of. So as I come to you, I'm a concerned mom of kids that are already grown. I'm a concerned Franklin County citizen, and I'm a really concerned advocate of families. The plan to transfer our Franklin County children to Spokane is haunting me. I think it's a disservice to our families. My husband and I are farmers here in the county. He's a third county farmer. So we've been here and been involved and paid taxes to Franklin County for many years. I'm also a professor at Whitman University, and I teach a course, Families and Society. So I think I come to you with a little bit of knowledge, and I'm going to share some of the research that I think that this plan really addresses. The juvenile system was created to assist children and families. And as the judges talked about today, it's a separate entity from an adult prison. Adult prison is to remove people from society and punish. The juvenile system is not set up that way. The purpose of a juvenile detention center is to rehabilitate, to educate and give care, as well offer service to strengthen and improve parenting techniques for those families. This plan, moving our kids to Martin Hall, is going to take children completely away from their families. It has the potential to break what is most likely already cracked. Let me share a couple facts about separating juveniles from their families, neighborhoods, and community. It's going to heighten the trauma that these kids have already experienced before they ever lay their head down on a pillow in a detention center. It's going to deny them access to community services, especially the need for mental health intervention. It's going to increase anxiety, depression, post-traumatic stress syndrome, not to mention lack of proper educational services. The average stay for a juvenile detention center nationally is 27 days. That's almost a month being separated from their families, from their neighbors, their community mental health professors, and their teachers. The family unit, including those siblings and the extended family, is fractured. And community support languishes. Out of sight, out of mind. Is that my 3 minutes? Okay. So I just really, I come to you I know that it's already in the works, but to say I really, really think it's not a good idea. They're going to come back. We're going to get them back. And I think that that's where we're going to really see the savings that we're hoping to get now. We're going to be spending when they come back.
Thank you.
So.
Anyone else in the room for public comment?
I would like to give you some additional correspondence to what you've been given in regard to the First Amendment petition.
I've already got plenty of them. I got like a dozen of them in the house.
Republican counties, the pink is the Democrat. Okay. So, Amendment 1, Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof, or abridging the free speech of the press or the right of the people to peaceably assemble, and this is the part I really need you to understand, and to petition the government for redress of grievances. That is what this is. That's a constitutional right. So next week, whether you believe this or not, the petitioning of grievances allows me the opportunity to speak to you about it. I'm saying this to your favor. There are limited and enumerated powers in the Constitution. We are facing an epidemic of violations. And where are we getting with initiatives? Nowhere. I've worked on them. If enough counties, I'm calling for a coalition of counties to come together and say, we are going to be constitutional. There's no law against that. And I don't think anything that Nick Brown or somebody can come up with says that they can tell you you're going to lose something in court on that, because that's where they're going to run. Impeachment is not a court process. Neither is removal from office according to Amendment 14, Section 3. There are other levers that I want you to be aware of that I would like to call the legislature to, and that is an investigative legislative inquiry according to RCW 44.16. Who is submitting these laws to the hopper that goes to the OPR, and then it goes to the AG office and gets blessed and comes back? There's a tribunal within the legislature, and that does make them shake, because the ones that are making the laws are going to be tried by those who are standing in the right authority. And it may look partisan, but this is actually just constitutional. There are other levers locally, and this is what I believe Brian is really trying to protect you from, is that if our county commissioners and our electeds don't keep their oath, there's a process of removal there too, and that is not what I'm here about. I'd rather see a coalition of counties. We have the Eastern Washington County of Governments.
Thank you. Is there anyone else in the room for public comment? Anyone on the phone? Hearing, seeing none. Executive session, do we need?
Yes, under RCW 4230, 110, 1I, all three subparts.
Mr. Chairman, I'd like to see us amend our agenda to put item 1 on our workshop before, or actually both of our workshop items. So I would move that we would amend our agenda to move our workshop to immediately start now, and then we would follow that with executive session as needed.
I second.
I have a motion and a second. All in favor signify by saying aye.
Aye.
Aye. Motion passes. Moving on to the workshop. LRA, less restrictive, alternative, and secure community transition facilities, presented by Stephen Bauman, Franklin County Commissioner.
Thank you, Mr. Chairman. Thank you for this opportunity, and thank you for this being on our agenda today. In the room with us today, coming forward, is the mayors of Pasco, Kennewick, and Richland. Pasco Mayor Charles Grimm, Teresa Richardson, the Richland Mayor, and Jason McShane, Kennewick's Mayor. And I've asked them to come today to share with us their more educated by need today because of what's going on in their jurisdictions, and have asked that they come and share with us the concern that you have, what you're doing about it, and so that we can glean from that and figure out how to approach this issue within the unincorporated portion of Franklin County. This issue has arisen of recent when there was an application made in a residential area to put a LRA house, a less restrictive alternative house, into a residential area of the city of Kennewick. And there is thousands and thousands of children within walking distance of this location. And this house is going to potentially house level 3 sex offenders And just as a marker, a point of reference, in less restrictive housing, level 3, the recidivism rate of level 3 sex offenders is 77%. So if you round the number by 3 points, that means 4 of the 5 statistically will reoffend. And so, Mr. McShane, if you would share with us, and Mr. Graham and Madam Richardson, if you would share with us some of your concerns, and the floor is yours. Thank you.
Thank you, Commissioner Baumann, and thank you, Commissioners, for hearing us today. I also wanted to bring greetings from Fred Brink, the mayor of the city of West Richland, who was unable to attend today, wished he could come and join with us to provide some information on this. For those that are unfamiliar, I'm going to just provide some background as I understand it. I want to point out that I'm not an attorney, nor do I sleep at a Holiday Inn Express last night, so I don't have that background. But I have done a fair amount of research into this to become aware myself and educated, and I'm providing that some of that education to you, and would encourage you to, and you'll hear some additional encouragements from me later as to what we can do to help each other on this issue. Just as by way of introduction, my name is Jason McShane. I'm the recently elected mayor of Kennewick. I have been on city council for 2 years, fulfilling an appointment, and was reelected in November of last year. I was selected by our council as mayor in January of this year. A week later, we had a press release go out from the District 8 legislators in our area, as well as the city, informing the community of a less restrictive alternative housing for sexually violent predators. I became very quickly aware that this was not what I had thought it was, as it had been provided to me previously. And I want to just address some of these things, and I apologize if I speak too plainly in these settings, but I find that too often we are speaking around issues. We call things by acronyms because of convenience, or perhaps to make it not seem as bad as it might be. And so you're going to hear me speak some fairly plain language as to what these things are. This is a fairly lengthy explanation because, quite frankly, this is a challenging law and a challenging understanding when we get to housing for sexually violent predators. And so by way of introduction for myself, I'm also a father of 5 children. 4 of them are still in our home, and we are all living in Kennewick. I have been a resident of Pasco at one point in my life and enjoyed that time and appreciate, the opportunity to speak here. Less restrictive alternative housing for sexually violent predators is not what people think it is when you initially talk to them. When I brought this to people's attention, most of what I heard was, well, we already have sex offenders in our community. As a matter of fact, if you look from within 5 miles of my home in Kennewick, there are 58 registered sex offenders. That's nothing new, right? Quote unquote. Sexually violent predators are a different matter. And so within the gamut of sexual offenses, we oftentimes don't understand where these would come. And so I'm going to just describe it in this way. As someone that initiates this and then is prosecuted and tried and then is criminally sentenced, sexually violent predators have to fulfill their criminal obligation to the state. They're incarcerated. Once that's completed, they are then, in the case of a sexually violent predator, they are then civilly committed or civilly confined because they've been deemed by the state of Washington and the courts to be too dangerous to be released to the general public. When we talk about registered sex offenders, this is a group that has been unconditionally released, quote unquote, to where they're able to, re-enter into society and find housing in that. This is the group we're talking about is not those people. The group we're talking about are those that have been deemed by the state of Washington to be too dangerous to be released generally to the public. And they've been committed, confined. I won't say the word incarcerated, but confined to a facility on McNeil Island that they call the Total Confinement Center. For those that are unfamiliar with that process, that's run by DSHS at our state. And then it goes outside of the control of the Department of Corrections because these folks are civilly committed now in that regard. And so when we talk about less restrictive alternative housing, and I'll make one correction to Commissioner Baumann if that's okay, there was no application made. There was no point of order where they came to the city and said, hey, we would like to put this in your city. Let's go through what that process is. In fact, what you'll find is that those limitations are the ability for a city to help to control where those would be placed are removed by state law, specifically stating that these are under the jurisdiction of the state and are not to be limited by local code or ordinance. That's really challenging when we have lack of local control when it comes to the safety of our communities. And as I share this opinion, and that's just what it is, it's my opinion when we get into these things. But the fact that we have sexually violent predators being placed in our communities with no say from the local jurisdiction other than to receive notice, not to receive the ability to comment back or to say that we don't think this is a good idea, but to receive notice that it's going to be imposed upon our communities is the limitation that's available in the law. And so as we're talking through this, I apologize to go and read the statute because anyone can go and read statute, right? But I think it's important that we read the definitions that are being given for these facilities. And I will not go through and read all of the items under the RCW where they identify what a sexually violent offense is. I'm going to leave that to be read by others. But under sexually violent predator, it's defined, and this is in RCW 7109. Sexually violent predator means any person who has been convicted of or charged with a crime of sexual violence and who suffers from a mental abnormality or personality disorder which makes the person more likely to engage in predatory acts of sexual violence if not confined in a secure facility. And so this is the law under which we see civil commitment, right? Civil confinement in the Total Confinement Center on McNeil Island. This is the definitions that we see behind that. What a less restrictive alternative housing item is it's meant to then provide for an opportunity for these folks to transition from total confinement back to unconditional release. This was something that was passed in the early 90s in challenge to the idea that we would civilly commit someone in perpetuity, that there's a right under the Constitution for people to be released and have a pathway to release from confinement. That's in our Constitution. We understand that. We recognize that for people who have been falsely imprisoned and other things. It makes sense. In the case of this, that meant that there was going to be some alternative to provide for this transition. In 1990, and I don't know how familiar you are with some of the laws that led to us having registered sex offenders in our state. There's a documentary that was done on less restrictive alternative housing in Tenino and in Enumclaw. During that documentary, they also go back through what was done in Washington State to help to provide for the requirements for registering sex offenders in the late 80s and early 90s, and also mandatory prison sentences for those. If you're unfamiliar with that, I would encourage you to watch this documentary to educate yourself on that. One of the things I will mention is that this is a viewer discretion is encouraged. It's not a video I would watch with my children. As they describe some of the challenges that were done and the things that happened during that time period that led to members of our state passing laws to require the registration of sex offenders, violent acts were done. People were killed. Children mutilated. And as we begin to understand why these things were put in place, I think it's stunning to watch the erosion of those protections in our day, not even 30 years later. So subsequently, in the mid-90s, it was determined that they needed to have a pathway to transition. And so in 95-ish, they started this path. There was like I said, from what I understand, there's a lawsuit that led to that. And so secured community transition facilities were then imposed by the state or provided for from the state or needed to be provided for. And in one of the reports to the legislature, it mentions that this was a judicial concept, meaning that it was not actually enacted. So yes, judicially it says that we should be doing this, but there was no implementation for almost 15 years. And so that fast forwards us to nearly 2010. And at what point they begin to create these secure community transition facilities. And when you read in the law, you'll find the secure community transition facilities are the section that are run by DSHS, not by a private provider. And there are two such secure community transition facilities. The first of which was built on McNeil Island, right next door to the Total Confinement Center. So this is 2 units, different transition. This has been described to us as being a place where someone can get out of a total confinement and into a home where they can do their own laundry, they can cook for themselves, they can start this transition back to society. And some of those things may seem to make some sense. This facility on McNeil Island, based on what we've heard, and again, I don't like to pass on rumors, but I'm passing on information that I've received. When this facility was proposed on McNeil Island, the residents who lived there, who serviced the total confinement center, were opposed to the placement of this secure community transition facility because it was too dangerous for their residents. So people that were servicing the total confinement center said, hey, this is not something we think is appropriate. I'm sure there were other proponents of the project, people that thought it was appropriate, as there is with all of these. But this secure community transition facility is what you read about in the law. And as you go through most of RCW 71, you're going to find cover secure community transition facilities. There are also other secure facilities. Those secure facilities are what we call less restrictive alternative housing. We've had DSHS call those community housings at times. Sometimes, like in the state attorney general's opinion on the issue, they refer to these as kind of like adult homes, where we have this house that's now being able to be, where sexually violent predators are being placed. This is what's being proposed in Kennewick. Within that jurisdiction, there are two different types, and the one is a home that has a contract with DSHS, and then there are others that have a contract directly with the court. So the Office of Public Defense has a contract directly with those. The one in Kennewick is currently being proposed as one that would be a contract with DSHS, but run by a private provider. As we talk through the different units of this and trying to understand what exactly are we seeing come into our communities, it is a little bit frustrating that these are things that have been on the books for decades and not information that communities really understand. If you go and look at where the placement of these is done, it is governed under the same RCW for the civil commitment. But it's quite frankly, it's challenging. When I started to try to learn on this and read through it, you're reading one RCW code that refers to another that now doesn't apply because it doesn't match these three conditions, and so you need to come back over to this, and so on and so forth. It's very, I would say, opaque and challenging for us to understand even at the local government level. For someone, in my case, who's been in local government for over 20 years. And so as we're talking through, these different elements, we get to, what does this really mean for us in Kennewick? What's this mean for, others around our community? And, we've been fortunate to have our other mayors here today with us and understanding, how we can protect the community's interests. As you can imagine, we have a number of concerns being brought to us by our constituents for this. And so I do have some more prepared to talk about. I would be happy to pause for a second and answer any questions that you might have as we talk about the background of these. But then I'll talk a little bit more about kind of the details and then what's going on now.
Any questions?
Thank you. I'm ready to keep listening.
Okay.
One
Go ahead.
question I have.
Please, Commissioner.
This was all put into place by the Growth Management Act in Washington State. This gives them the right to do this. I've asked Mr. Danzel, and I was opposed to this when it came into Franklin County. I've asked Mr. Danzel to help us get out of the growth management. This is why Olympia is able to do this, is because of the growth management. And so we all, and I got asked, and I don't even know if you know, were you asked to be part of growth management? Because the county commissioners were, and I was in the room as a citizen opposing it. They dangled a $150,000 carrot, and they leached onto it like a bass on a lure. And that's how we got into it. And we need to get out of the growth management.
Yeah, and I, again, trying to become an expert on this issue for our community, I don't know the exact details on whether growth management would affect this particular subject or not.
It does. It gives them the right to do it. If they can, that's all based on growth management, is how they can place this in our areas.
Yeah, and like I say, I would defer to others that have more experience than I on that.
Thank you.
I guess my question would be, how do we protect our area of counties from an intrusion of these types of homes?
Yeah, and I'll get to that next, if that's all right.
Sure. Thank you.
And I don't know, Mayor Grimm, did you have anything you wanted to add at this point? Okay, all right. And so as we talk through these different components, again, I'm going to just briefly review, right? Sexually violent predators fulfilled their criminal commitment, right? Criminal incarceration period.
They are now civilly committed because they've been deemed too dangerous to be released. They're being given a transition pathway to release into our communities through these secured facilities or secured community transition facilities, community housing situation. As part of this rule, annually as a minimum, the Office of Public Defense has to bring back a sexually violent predator to the court for consideration for release to one of these less restrictive alternative housing or an unconditional release as a minimum. They can do it more often than that, but as a minimum they do that. From what we understand from Department of Corrections, the court where that is being held is the county of which the crime was committed. And so if a crime was committed in King County, the court that's reviewing this sexually violent predator's release is in King County. They can then petition and say, we think that the release should be allowed, and there's a number of conditions related to that, and we think that a house in Kennewick, for example, meets those conditions. The judge in that area reviews that, issues a request to the Department of Corrections to go and review the site to meet those conditions, and then it comes back and that judge gets to make that determination for our county. And so you could have a judge not accountable to the citizens of Benton County making a decision that affects the safety of Benton County residents or Franklin County residents or whomever it would be. There's no standing for the Benton County prosecutor to be involved in that. If the Department of Corrections does a poor job with, and not that they would, but in the event that they make a mistake, there's no standing for the Benton County prosecutor to challenge the findings of that report and the issuance of that for the Department of Corrections to the judge. And so what that means for us is that these less restrictive alternative housing units, not the secure community transition facilities. Secure community transition facilities are again run by the state. They have a section of the law that talks about their placement and code as to where they can be allowed. There are 2 of those in our state, one on McNeil Island and the other one in King County. Those have provisions allowable. So there are some local codes and ordinances that can help to place those in our communities. These, what we're going to call community housing, and again, that's the terminology we had from a member of DSHS. That's not a codified law, right? But these housing units that are either contracted with DSHS by a private provider or contracted directly to the court by a private provider do not fall under those requirements. And the requirements, as we understand it, when this house becomes available, or when a house becomes available, the Office of Public Defense can petition the court for the placement of a sexually violent predator into our neighborhoods. And at that point, Department of Corrections does a review, goes back to the court says yes or no, and that person is placed. Very little that can be done by a local government. In fact, and I again apologize for reading directly, but I think it's important. The State Attorney General's opinion on this issue, let's see. So the State Attorney General's opinion on this issue says in part, I apologize.
The current State Attorney General or the former?
This was the former Attorney General who's currently the governor of the state, yes, just to make sure. Bob Ferguson, yes. Yeah, and I apologize. I've been looking through a couple of different pieces in this, and so.
While you're looking for
There it
that.
is, yeah.
Go ahead.
No,
No,
okay.
if you found it.
So this is a question related to local governments. This is a question of, may a local government prohibit or contest the release of less restrictive alternative placement of a person involuntarily committed to a state hospital or facility? And they talk about these under different RCWs, but the one we're talking about is 7109, to a less restrictive setting, and in part here, and what qualifies for that. The entitlement to this, the very first paragraph on this says, local governments may not categorically prohibit or restrict the release of or less restrictive alternative placement of a person involuntarily committed to a state hospital or facility. Attempts to do so through local ordinance may risk violating state or federal constitution or statutes. So this is their summary. And as we get through this, what we find from the previous state attorneys general's opinion is that there is no local court ordinance that can be enacted to prohibit this. And again, we're not talking about the secured community facilities that are run by DSHS. We're talking about these more community homes, right? And so there are a few things that provide for restrictions by the state. So state law provides restrictions. And so some of those things are codified under the law with a specific distance requirement. And in this case, so for example, and this again is in RCW 7109, courts shall require a minimum distance restriction of 500 feet on the proximity of the person's residence to childcare facilities and public or private schools. Now, private schools are defined elsewhere in the law, right? So a private school like a preschool does not count under this from what we understand. Providing instruction to kindergarten or any grades, and the courts shall require a minimum distance restriction of 500 feet on the proximity of the person's residence to those facilities. And that's paraphrased, obviously, but this 500-foot rule is limited to just a daycare or a school. A public park is not statutorily minimized to 500 feet. There are, however, thankfully, within the law, sections where they talk, again, this is out of the RCW 7109's definitions, risk potential activities or risk potential facilities, which in part says that these are any activity or facility that provides a higher instance of risk to the public from persons conditionally released from the Special Commitment Center, sexually violent predators. Risk potential activities and facilities include public and private schools, school bus stops, licensed daycare and licensed preschool facilities, public parks, publicly dedicated trails, sports fields, playgrounds, recreational and community centers, churches, synagogues, temples, mosques, public libraries, public and private youth camps, and others identified by the department following these hearings. And so there isn't a statutory minimum from those. It's just simply that they need to be taken into consideration in this release. That 500 feet from a daycare facility is a challenge for the state. And in fact, in a state report that was requested from the state legislature that was issued in December of 2022, one of the things they talk about in their recommendation, they have 3 recommendations for these LRAs to help them to be more effective in the state, meaning that we can place more people in them. The recommendation number 1 is that the 500-foot rule that I just read is stricken. They want to remove that. And so this is, again, a report that was issued to the legislature in December of 2022 as a request from the legislators on what can we do to use this provision of the law more. And so fortunately that has not been stricken as of now, in this person's opinion. That's a fortunate thing that it hasn't been stricken as of yet and needs to be, quite frankly, probably needs to be improved and enhanced. This is obviously a challenge for all of our communities as we talk through what this really means. And so my point in highlighting that comment is that there are those within our society and within our state legislature that think that we are being too strict when it comes to the placement of sexually violent predators, and that we should loosen those rules and allow more of that to happen within these communities. In addition to this issue, there is a fair share philosophy that's being proposed or not proposed, is enacted, where they are trying to distribute out sexually violent predators back to the counties of origin. Not necessarily sending someone that committed a crime in Franklin County to Franklin County, but if you had 4 sexually violent predators on McNeil Island from Franklin County's fair share is to receive 4 of those sexually violent predators back. Maybe from other counties and maybe not just from Franklin County. But so they are in the process, they being the Special Commitment Center and the Office of Public Defense, are in the process of following the mandates given to them from the state legislature to place folks, sexually violent predators, around the state in this fair share principle. And so it is going to be coming to communities across the state where it already has been. Please, Commissioner.
I want to add just a little bit of perspective as you're talking and describing, the distances from these predators. And so there's over 7,400 children in Kennewick within 2 miles of this school. And when you go and you start breaking this down, Tritech Skills Center is 1.8 miles away, is 1,100 children. Edison Elementary is a half a mile, 355 children. Kamiakin, 1.4 miles, nearly 2,000 children. You go through and you look, we have a community pool that's less than a half a mile from this facility. You have Legacy High School, nearly 200 children, that's just over a half a mile, and it just goes on and on and on. And they are trying to make it to where that you can't possibly prevent it. And I just so appreciate you coming today to talk to us, and look forward to the rest of it. And I'm thankful for our state representatives. Senator Nikki Torres has tried to run 8 different bills that have failed in trying to help protect this. And so please continue on, but the perspective of within a short walk of this house, the house proposed the placement is 8th and Edison in Kennewick is where this sex offender house is that we're talking about. So please.
Thank you, Commissioner. And,
If
yeah,
I
please,
may,
Commissioner Dieter.
yes, you've referred to DHHS, and I want everybody to know what DHHS stands for. It's the Department of Health and Human Services.
Yeah, Department, yes, Social and Human Services.
Yes.
Yeah.
So with that, in this agenda report that I got from Pasco, in the background, history and fact briefs, it says right here that under Washington's Growth Management Act, secure community transition facilities are classified as essential public facilities. So it all falls underneath the Growth Management Act. And that's why I've asked Mr. Danzel. He was very effective in getting Stevens County, Ferry County out of the Growth Management Act. I've asked him, let's start looking at how we can get out of this. And I think Benton County needs to do the same. And we get out of this, and that way they don't have any jurisdiction over us. We control our own county. And we need to really work on that to try to work together to defeat this Growth Management Act that is killing us in our planning too. They're very, very influential in their power that they've been given to by this state. So we need to undermine that and get out of it.
And like I say, for my sake, as we talk through, the different avenues and action, one of the things that we're requesting as part of coming here today is that coordination effort. And I think it's incredibly important. You see the mayors of the cities here. Again, Mayor Fred Brink was not able to attend, but had wanted to join us. You see the mayors of the cities sitting here saying, this is something we all need to come together on and provide
Yes.
partnership and figure out the best way forward for us to protect our community. And it's really how that communication
If I might add, 500 feet is less than 170 yards. That's not even 2 football fields. That's how close they can be to a school. That's ridiculous.
It's incredibly, like I say, it's incredibly ridiculous for us to be, really even having this conversation right about this.
Exactly.
But bringing heightened awareness to this is kind of the critical element. And again, I'm not an expert on these issues, right? But what I am is I am a father.
Yeah.
And, I think that it's really important that our communities know what it is that's being proposed and what's being pressed. Commissioner Baumann talked about, the state legislature this year. We really appreciate our District 8 legislators, Nikki Torres as well, who pushed forward these bills. They had a hearing on one bill. The rest of them were not even allowed to go to hearing. Mm-hmm. The one bill that was proposed was simply to have more transparency as to who owned the home, and that the person owning the home would also be responsible for the home. There was some discussion about, constitutionality, and you can't imagine they're all the providers. This is all smoke and mirrors. This was about trying to make sure that the people that are owning the home are accountable in the event that home actually was able to go through. That received a hearing. I testified for that bill at that Senate hearing, and heard a number of things from folks that are trying to push this forward in our state, that are employed by our state. And trying to understand, where's the motivation to this? But I think you have to understand, when we're fighting this fight, again, most of those bills were focused on just communication. Instead of a 30-day notification, a 90-day notification. Doesn't seem like too much to ask to say that, hey, if this is going to happen, we should have a notification to our community. The police chief or the Franklin County Sheriff would need to be notified that this is ongoing. 30 days, that's what's under the law. We asked for more. Those bills weren't even given a hearing to be considered and communicated. We're over here fighting this fight, gentlemen, and the challenge is on the other side of this. There are 2 bills that made it through that are being considered. One of those is to reduce the penalty for a predator who is online, and again, I'm describing this as best as I understand it. I maybe misunderstood some things, but from what I understand, a predator who is online communicating with a 13-year-old with an intent to to sexually prey upon that person. If it turns out that the other end of that line was that 13-year-old wasn't a 13-year-old at all, but was a police officer, it's now going to be a lesser charge, just because it wasn't actually a 13-year-old on the other end of the line. Okay? That's one bill. Another bill in our state right now, if you fail to register as a sex offender in our state twice, it's a felony. They're trying to reduce that penalty. And so as we're having this communication and we're talking about transparency, we're talking about 90-day notice instead of 30-day notice, there are bills that are being proposed by certain members of our society that are trying to reduce the penalty in the first place. And I think that we need to understand this element of this as we are beginning to go about this challenge. Because again, the question was asked, well, what do we do? What can we do, right? We're the leaders of our community, elected leaders of our community. What can we do to protect the citizens? That's one of the most important things that we've been charged with as elected officials. And you have to understand that the challenge we're facing right now is not only are we not able to make headway on less restrictive alternative housing, but we're seeing the erosions of these protections. I'm going to go back to this documentary that I watched. It helped me better understand the situation that we were in.
What is the name of that documentary?
I believe it's called The House, but specifically it was a documentary about a less restrictive alternative housing proposed in Tenino in Thurston County, and a less restrictive alternative house that actually was in Enumclaw that was then ultimately shut down. And, you know, the folks that went through that, the section in the middle is the section that was most impactful to me as I watched mothers, I watched the police investigator, you know, talk about the heinous crimes that were committed that led to us finally getting to where we had mandatory prison sentences for these sexual crimes, that led to us finally requiring registration so that the public could have some level of protection. And to watch those protections begin to be eroded in our day, it made me say that this was not going to be the generation that I was a part of. That we had to stand for those that can't stand for themselves.
That's right.
And so as we talk through this, we have to recognize that this is the opposition that we're up against, and that's why it matters, right? And one of the, I was telling Mayor Richardson today, you know, one of the challenges for me as I've been through this now and people see you out in the forefront of this is you start to hear stories of their survival and the challenges in our community that are being undertaken. And you know, there's a lot of misinformation that gets displayed. There's a lot of information that gets cast around. We had a person stand up in our town hall that we had in Kennewick and describe, you know, these people as perfect gentlemen, and then proceed to tell her story that she had been molested by her husband and her 5 children had been molested by her husband, who in her words was a pastor or a member of a local church. And her comment is that these people are just down the street from you. They're not always the ones confined. And her misunderstanding is that we're not saying that that's okay. Right, that somehow or another that our opposition is to people that have been committed, people that have committed these crimes and have been civilly convicted and then committed because they're too dangerous. We don't want those in our communities, but somehow or another we're okay with this other idea. No, we're going to find that, and we're going to protect those people that are less vulnerable, that are more vulnerable, and we're going to protect them both here and in the future. And so, you know, there's a misunderstanding, you know, and we've had a lot of complaints in Kennewick that, you know, this is a not in my backyard situation. I will say this again for anyone that has any concerns, this is not in anybody's backyard. That's my opinion, right, is that we have to find a better way as a society. If we need, you know, as we need to, you know, find people community transition, we need to find a better way than putting them in the middle of city. 8th and Edison, if you're familiar with the geography, is essentially almost smack dab in the middle of Kennewick, right? And it's in the middle of a wonderful community near schools, near pathways, near parks, right? Not far away from any of those places. There's a private homeschool across the street that under the current law gets no consideration. And so those are all things that we need to change. And so happy to answer more questions. Yeah.
In your thought process, the moratorium that Pasco is contemplating passing will have no effect?
It depends on what's being proposed. So what we understand, I mean, this is the challenge. There's no moratorium that Kennewick can issue on a less restrictive, what we call these community housing, because there's no application being provided to us. So what are we putting the moratorium on?
Not even being informed.
What are we putting the moratorium on? Now, some of the code changes that you've seen proposed on the less restrictive alternative housing, from industrial going to light industrial, I do think that has merit, especially for the secured community transition facilities. These other types. I definitely think we need to do those things as a community. And again, this is just my opinion of the world. I think we need to do those things as a community. We need to do whatever we possibly can to help change the state law. But this is kind of the beginnings of that.
This state has become very soft on crime, as we have been informed by you and what have we have witnessed in what's going on over in Olympia. And that is why, as Franklin County Commissioner, I would like to see us either join Idaho or create our own state with Oregon and opt out of being a Washington state citizen, because we are not in eastern Washington soft on crime. We want a penalty for the crime. You do the crime, you do the time. And we don't let sexual predators prey on our children in this side of the state. I want to thank you, Jason, very much for your warranted effort here and your warrior attitude. Thank you.
Thank you, Commissioner.
Good evening, or good morning. I guess usually I say good evening when I'm behind the microphone, but good morning, commissioners, and thanks for the opportunity to be here. And, thank you, Mayor McShane. I mean, I feel really bad for him because the position he's in could be any of us. Okay, and he's had to immerse himself into information he would probably rather not put through his mind. I, too, am a father of 5 children. I, too, I was voted into council 2 years ago and elected to mayor just a few weeks ago. So as I'm hearing you say all this, I'm just realizing how easy any of us could be in this position. And this should be a wake-up call. And in our discussions this morning, it should be said, yes, Mayor Fred Brink of West Richland is also united with us. We actually met with him this morning also to discuss this on our way here. But like Mayor McShane said, he just had another obligation that couldn't make it here. But it seems like we're all united on this, but I think it's really important, the point he made. Senate Bill 5312 that is still alive in the Washington State Legislature is trying to lower the penalties and there's advocacy groups behind this. There are other state legislators behind this trying to minimize the penalties for these, just because there's no said victim, because it was a police officer instead of a 13-year-old. That to me is really kind of scary, that we have forces. I believe, as he was kind of pointing to, the number one role of government is to restrain evil. Okay? And I assume all of us in this room would call this evil. The problem is there's people now in our society who may not call this evil, or who may want to minimize that in certain ways. And that's really kind of the battle we're up against. Yes, we are up against the state legislature. We can't even, because of the Growth Management Act and other things. I mean, I believe in the principle of subsidiarity, which is government at the most local level possible, starting in the foundation of society, our families, our neighborhoods, our churches, then our municipalities. The farther you get away from a problem, the harder it is to fix. Okay, and I think this is a prime example of the state trying to fix a problem, and it's really just another unfunded mandate upon counties and cities across the state. Them telling us how we are going to, or just what we have to do, how the people we have to take on that may be and have proven themselves to be a threat to some of the most vulnerable people in our society. This is very scary, and talking with Mayor McShane earlier this morning, it's really kind of a wake-up call too, that we just may not have the resources, the laws, the ability, or just even the codes to even fight this. This is coming down from the state. I read a lot of comments online. I looked at a lot of the discussion, and so many people want to, put the onus on Kennewick. What can you do about this? What are you doing about this? You fight this, and we will do. I think we're all committed to doing everything we can at the municipal level, but our battle is really with the state. Our battle is with, sadly, even our culture and society right now. So we are committed to doing everything we can here in Pasco, and I believe the feeling is very mutual across here, but it's going to be an uphill battle.
I wasn't planning on, do I need to turn on my, no.
Pull it a
It's
little
already
closer,
on.
please.
Yes, thank you. I wasn't planning on speaking because, as you can see, these guys do a good job. But I am here as a person like you in learning about this situation and realizing that we represent people that want something to be done, but so often we're told, well, I can't do anything. And so we look at Kennewick thinking, I'm glad it's over there. And it wasn't in Franklin County, it wasn't in Richland, but it's only a matter of time that we're going to be facing that here. And so what we'd like to fight and do and be a part of, united, is what can we do now to educate the community to either get behind some bills and register our opposition to that, look at our legislators, but then also what can we look at with our current codes and policies to keep this out of our community. Your story of the watching the movie, very moving of people's experiences that have gone through this, and we're in a position of leadership now, and we need to protect those that are more vulnerable. So that's all I'm going to say at this point, and just thank you very much for your presentation.
Yeah, thank you each so much. And I also wanted to acknowledge Shelley Harper, the mayor of Connell, is in the room, and certainly would be happy if you felt like you would like to say something. Certainly happy to have you two, but really appreciate each of you mayors recognizing this, and selfishly, as in Franklin County, as she acknowledged, I'm glad it's not here, but that doesn't change it. It's our community. And, collectively sitting here, we represent somewhere in the neighborhood of more than 250,000 people. And for such a time as this, we are here, and what are we going to do? Just to have a little bit of a conversation with you, Jason. You and I have spoken a couple of different times about this to some level. Where do we go from here? And our legislators want to help. How do we do that?
Yeah, I think it's a really good question, and I appreciate the words that have been said. And so, the first things first is to get and again, for those that are unfamiliar with local government, right? As the mayor of the city of Kennewick, I lead the city council. I am not the CEO of the city. The CEO of the city is the city manager who the council hires. And so having our hired CEO, the attorneys that we have employed by the cities meet to help make sure that we're going through every piece of code, ordinance, law, to understand if there's anything that we're missing, I think is appreciated. And so coordinating that effort with the professionals at the cities is going to be critical. I think in addition to that, we are already working with, and we will need to continue to work with our District 8 legislators, the 14th, the 15th, and the 16th, to say these are changes in Olympia that we can make to the law, things that have meaning. I am not interested in virtue signaling. I'm interested in making change. And we have got to make sure that whatever we're proposing has been run through everything. This bill that did get a hearing, the Office of Public Defense had 2 different attorneys on, and they talked to the fact that this bill is non-constitutional, cannot be done. We cannot have any doubt on bills that are going to Olympia, right? In this session, we were trying to do whatever we could. But the reality is we've got to have all of those things nailed down. And so our state reps are going to need to be involved in that. Our local government's involved in that. I think there's power in unity. I will say this to Commissioner Didier. I've met a lot of people across the state now in the course of the last month, had a lot of phone calls. I'm going to tell you this, that I have not met a single person that thinks that this is a good idea. I've not met a single person that thinks that this is the way that we should move forward, with the exception of people that are personally either profiting or through rents, or their employment is related directly to this program. Not one, with the exception of a state advocate who was the one that was proposing to lessen some of these restrictions. And so, like I say, this is a nonpartisan issue. This is an issue for families across Washington State, people on the west side, people on the east side, everywhere need to be involved in this. They need to know what's happening so that they can be aware. And once they're made aware, like my 12-year-old daughter said, Dad, this just doesn't make sense.
And if I might add to that, we have an initiative process, and we have numerous times passed bills or initiatives to lower our car tabs. And yet we got a Supreme Court that overturns it every time. Every time the people step up and speak, it's overruled by the state Supreme Court. So how we're going to change this, I don't know, because that is where it'll go, is to the state Supreme Court. And to be honest with you, I think we have rigged elections in Washington State. That's a whole nother topic, but I think we need to go back to a precinct showing our ID to vote. I think we have problems here in this state with elections.
Well, and Councilmember Anderson at our last city council meeting reminded folks that elections have consequences.
Yep.
And as we're making choices in who our elected officials are, it has consequences. And I'm not trying to be partisan or anything. It's just, as you look at the character of the person that you're voting for, that person has to stand and be principled and be able to actively pursue the things that the people of the state of Washington are interested in. And I can tell you from my experience, people are interested in being safe first.
Yes.
So, Jason, thank you so much for coming. You and I spoke and kind of brainstormed what if and how would we do that and what does that look like. And so an idea that I have not shared with my fellow commissioners because I haven't had that opportunity yet, but the town hall that Kennewick put together in the school, it was packed to the edge. I wasn't feeling well that night. I did attend virtually, but wasn't in the room. What if we were to do that as a region? What if we were to bring together our four cities, the big cities and the small cities within Benton and Franklin counties? We were to have our two boards of county commissioners to come together and hold a joint town hall at, the Hapo Center or the Convention Center or something like that, and ask the community to come and speak. We can ask them to verbally speak, but ask them to also submit their concerns in writing and begin a process. Ask our 8th, 14th, 15th, 16th district legislators to be there and be a part of that. That could be a pretty big deal, but as a region of 330,000 people, that's a pretty big voice. And I'm like you. I have heard no opposition to figuring out how to do something about this, with the exception of the people that are financially motivated to oppose it. We can't just virtue signal. We got to do something. Not sure what that is. What's your thoughts?
Yeah, I think momentum is an important thing, and I think as we talk through, what really would create change. Again, what are we really going to do to change this? Obviously, it's laws in Olympia. That's the first. That to me, we've got the local things that we're working on already that we're going to do independently of this, right? We're going to fast track that and get those things done. But we really need to change laws in Olympia. And so, I do think it's important that people in our community feel heard. I think we've tried to do that. I think we're doing that today. The different mayors here today with our commission, Benton County Commissioners has had a similar meeting with their commission. People are seeing that their elected officials are listening to what their concerns are, and we're providing that. I think the next large meeting that we have, and I do think it would be impactful to have elected officials from all of our jurisdictions, including our school districts, who are also here to protect our children. I think having a meeting where we can present to the community, this is what is going to be proposed to be changed, where we come with answers, not questions, right? These are the things that need to be changed in Olympia this next legislative session, and we need to voice that opinion strongly. Having a united front, and again, we may not have every elected official in Tri-Cities may not approve of this. That's possible. It's unlikely so far, based on my communications with the constituents, if you base it on the numbers. I'm a numbers guy too, right? So you base it on the numbers. Most likely that wouldn't be the case. But having all of our elected officials locally, including our school districts, in a joint session would be impactful. And I do think that that would be important. I think laying out for the community, these are the demands that we have for change, I think are critical. And I think that's what we need to focus on. So right now, my focus obviously is working on state, local codes, what we can make changes on. But then the next thing to focus on is what are those legislative changes? And those are going to be best made, I think, in concert with our state ledge folks now and their staff, as well as the local offices here. It's going to be a combination effort of prosecuting attorneys, I think, to help understand what the law would make sense for them and how it would fit. And doing that coordination, I think, is going to be critical. And I think that starts right here. I said this at the town hall meeting for Kennewick, which we describe as a town hall meeting for Kennewick. That meeting was intended to be, and my request to our city manager was to have the two state agencies who administer this program come and sit before our community and be accountable to our community. That's what that meeting was. We facilitated it. We call it a town hall, but it was the state agencies coming and being accountable to our community. And I think that they didn't get all their answers out. I think the community had a lot of concerns, a lot of questions, a lot of confusion. And I think getting more information out, I think, is going to be critical. We'll continue to do that. But I think, like I say, the next step is to draft legislation, get it ready, and then present that to the community so that we can have more community input and then that support. I will say this, that recently, if you've been tracking the millionaire's tax, as it's been deemed, and the number of voices that signed in opposition for that, records were set and so forth. There's claims of dishonesty there. There's claims of misrepresentation. If you've seen any of those things, having 300,000 people in the Tri-Cities represented, saying this is what we want, is not going to be enough. Right, we're going to need to get help from across the state. Again, there are people all over this state that do not think this is a good idea and the law needs to be changed, and that's what we got to focus on, is building that coalition.
Mr. Mayor, would you share with us kind of what the city of Pasco's thought is on the moratorium that you passed, I believe, last week? Would you share just a snapshot of kind of what the thought process is there? And I believe that you're required to have a public hearing within 60 days. And just thinking about process, would you share with that?
Yeah, thank you. Part of it is honestly just to buy time to try to get this right for our community, for the community to have a voice, to hear their concerns, and for those concerns to hopefully be echoed all the way to Olympia, and look at zoning possibilities, anything we can do to mitigate the effect on the most vulnerable in our community. Does it move these housing to a light industrial area? I hope so, but the way the state's kind of rigged this, where they say they've got to be around services, they've got to be around these other facilities and assets and infrastructure that put them smack dab at 8th and Union in the middle, or 8th and Edison in the middle of our communities. And so yes, we want to look at all of those, have discussions amongst ourselves, have discussions with the community, and like Mayor McShane said, have that talk with our legal representation, our city manager, and turn over every rock. What can we do at the local level to fight this, to mitigate this, and to, I guess, let it be as least impactful as possible on our community? Because I think that's one of the most sobering things through all this, kind of what I introed with. This could be any of us. This could be anybody's community. This could be anybody's neighborhood. And what can we do to protect that? So, yeah.
Well, thank you. We could continue on for a long time, I'm sure. So here's the idea that I have is what if we give ourselves, approximately 6 weeks to try to come up with something, what our proposal is, and say maybe that we kind of aim towards that time to maybe try to assemble the larger group. I don't know if that's quite the right timing, but at least let's work on talking about it, figuring out what is, I haven't found a book that said here's the way to do this. No. And so let's work together, and thank you for spending time with us and sharing your concerns, your thoughts, and as a father like you, I am very concerned of what this does in our community, and for them to deliberately make it so that we don't have local authority is really concerns me. And so, thank you each so much for coming.
Thank you.
Yes, thank you for coming in.
And I'd just like to say thank you very much. I had a great presentation, and I'm in agreement with you. Numbers matter. And I think numbers in the Tri-Cities will matter, but when the people are ticked off enough, and we take 1 million people over there on the courthouse steps, I think that will make a statement, or millions of people. And that's what it's going to take. I'm a grandfather of 12. God forbid somebody messes with one of those kids. But this is what we got to do. Numbers matter, and thank you.
Thank you all.
You want me to chime in at all?
Please.
Mr. Chairman,
Yes.
you know, as a former state senator, one of the things that I would recommend is that there's more challenges on the floor.
Talk closer.
That there's more challenges on the floor to the constitutionality of each bill as it's being read or being heard. And then the other thing is there are many, many procedural motions. If we, and I think that this is true because I believe that it's a bipartisan agreed upon thing. What would have to happen is there would have to be 6 Democrats that would come over and go to the ninth order of business. They could pull a bill, they could change it, they could amend it, even without the consent of the majority. So all you need is of the majority party. So there are certain ways and certain things. There are divisions. You can call for, when I was there, I've just looked this up, it's illegal, it's not allowed anymore, but used to be what's called paper the desk. So you would handwrite amendments, as many as you could, for bills that were like, didn't make any sense, and you tried to out time, you know, force people to sit there, because then each member of the entire body gets 3 minutes to speak on each bill. And so are things that I personally believe that we could talk about strategy-wise that would continue to throw wrenches into the system and that we should be doing. I mean, that's just my opinion, is if they've got the rules that govern, and it's Reed's rules, it's a little different than what we all use, then you can do quite a few things from the minority. And I'd love to talk strategy with you all about that. Thank you.
And thank you again. And like I say, the commitment of time and resources, you know, I think we've had this conversation. This is probably one of the most important things that we'll take on in our time. We saw another important thing earlier today on your commission's docket. So we recognize this is not the only issue that you guys are having to deal with, and appreciate you taking the focus.
Thank you.
Thank you all.
Thank you for your time, and thank you for fighting and standing up for the citizens. Thank you. Moving on, update on comprehensive plan presented by Wes McCart, Franklin County Planning and Economic Development.
At the end.
Well,
Mr. Chairman, could we take a 5-minute recess, please?
We're going to take a 5-minute recess.
Thank you.
and we're supposed to open with public comment.
I missed it.
I didn't catch it either.
I did. I was hoping no one else would. All right, we've come back from recess, and we are going to move into public comment for workshop items only. Is there any callers on the phone for public comment regarding the workshop? Okay.
Caller, you have 3 minutes.
Hi, yeah, can you guys hear me?
Yes.
Okay, perfect. Good afternoon. My name is Jeanette Romero. I am a co-lead of a local nonprofit organization, Save Our Children Tri-Cities, that the neighborhood established to fight this LRA. I reside just one house away from the proposed location. First, I would like to thank you for placing this important topic on the agenda for discussion. I also want to address those in the community who have asked how they can help. One of the most impactful ways to stay informed is by following our Facebook page, where we regularly post updates about our ongoing efforts. We hold weekly peaceful protests to maintain community awareness and momentum, and we recently aired a statewide awareness commercial through Apple Valley News. Additionally, we are organizing a fundraising auction to help cover the anticipated legal fees. We met with an attorney this week, and we received an estimated quote of $40,000 to $80,000 for representation. We are confident in this firm's ability to effectively advocate on our behalf. But again, we are fighting this on behalf of the community. It is a big, big monster for us to kind of tackle. So any support that we can get, we are grateful for. We will be sharing details about the upcoming auction soon, and would be deeply grateful for the community support and attendance. Staying engaged through our Facebook page is a simple but yet powerful way to spread awareness and remain updated on our progress. Thank you for your time.
Thank you.
Facebook page? What is it?
Yeah, the Facebook page is called Save Our Children Tri-Cities, and there is a wealth of information on that page. That documentary on tonight is also listed on there, along with a lot of other resources and useful information for anyone wanting to get up to speed.
Thank you.
Perfect.
Thank you.
Thank you.
Any other callers on the phone?
Thank you for calling the Franklin County Commissioners meeting. Go ahead and begin your comments. You have 3 minutes.
Yeah, my name is Tony Sabino. I'm out of Kennewick, and I'm calling just to oppose the LRA. I'm also part of the community group that Jeanette spoke of, and whatever help can be given by yourselves would be greatly appreciated. We have had meetings with the mayor. We've had meetings with the city council. We're meeting again with the school board tonight. And we just need the entire community to get involved and to help us. And whatever you guys can do to help us, we would greatly appreciate it. Thank you very much for your time.
Thank you.
At meetings with the city council, we're meeting.
No further?
That's it? All right, anyone in the room for public comment regarding the workshop items only?
I wish I could change my name and face, but I can't. A couple years ago at my church, we had a Benton County Sheriff that's assigned to a special task force. I think there's only maybe 3 in the states. And they work with SARC, which is the Sexual Assault Resource Center. And they are the police officers online that pretend to be children that catch these guys. And would you not be surprised, out of the entire country, where the highest concentration of algorithms on Facebook and other platforms, especially gaming platforms that have a way to communicate with somebody you're gaming with online, the highest concentration of that algorithm in the country is not Las Vegas, it's not Chicago, it's not New York, it's not Miami, it is Benton City. Let that sink in. I don't know why. It's no shame on them. Something has coalesced there. And they did the sting operations, one in Yakima area, and then, of course, you know, the Bunch Finnegan and all that stuff. It took them a very long time to go over all of those videos they had to watch. The biggest sting operations in the country, the one in Yakima, they had an animal spreader along with knives and guns coming at these children, grooming them through the back door of the conversation. My concern is you understand this is not constitutional. And I'm going to circle back that we do not have a representative government in this state any longer because DSHS is the same culprit that is hiding all of these illegal aliens that are now participating in our voting process. We had our own county sheriff's office prosecute a very tiny part of that. But we have an executive government and a majority party that is continuously passing bills to hide those people and to protect their identity from ICE and everything else, so that we will never get our representative government back. And it is the federal government that we're calling for to help us restore that. And the removal from office is not a Supreme Court issue because it's not losing life, liberty, or property. It's simply prosecuting the moral perjury of disregarding your oath to the U.S. Constitution. So I circle back, and this is the reason I brought this particular correspondence that you have to begin that process to get a representative form of government, because then everything else can be taken care of behind that. So please read it, consider. I will be back next week. I'm with you. Let's get our intelligence and our intel on the Constitution back in place, because if we call on the DOJ to deal with this invasion, you will have all of your other issues solved. Thank you.
Public comment, please come forward. 3 minutes, and it has to regard the workshop.
Good morning, Commissioners.
Good morning.
Chris Lee, Chief of Police for Connell. Speaking both as a Chief of Police, but also as a resident of Franklin County. Excuse me. I want to thank you guys for doing this, because it's important to know that just because this is happening currently in Kennewick, there's no doubt that it's going to pop up in Pasco. Currently, the way the law is written, it's not going to occur in Connell. But as we have seen with the legislators, they're willing to massage whatever it takes in order to make something happen. So it could very easily occur in Connell, Basin City, Mesa, Eltopia, Prosser, smaller communities that may not have the same amount of resources that Kennewick or Pasco may have. I don't want to rehash all the stuff that you had already heard. I want to echo the importance of everything. I was present during the town hall in Kennewick, and that was impressive. Very impressive to hear from the community members. So, Commissioner, yes, I would agree that having a joint meeting to hear community members' expressions on their concerns would be great. My fear with that would be is they would just be hearing the same things magnified times 300,000. So we can take that as a sample of concerns that are probably going to be shared equally in Franklin County. But one of the things that I haven't heard yet so far this morning that I wanted to bring to everybody's attention is that they would not talk about the training levels of the staff members that are going to be in control of these facilities. We have no idea what their skill level is, what their training curriculum is, or what their capabilities are. They would not talk about it other than it was an OJT and they're fine. I've got concerns with that. We have, again, I want to echo that these are the most dangerous sexually violent predators. And for the state to have deemed that, that's pretty significant for the state to say that these are dangerous people, especially since currently the state doesn't really want to identify much of anybody as a danger. But there is no training requirements published. We have no idea what their expectations are or what their capabilities are. So it's going to be relying upon local law enforcement resources in order to be able to address these issues if something was to go wrong. The other part is we talked about it as far as being a moneymaker. What they had said at that meeting was each person would range from either from $1,800 to almost $25,000 per month to house them in those residences. There's no doubt it's a moneymaker. It will be coming to Franklin County if we don't do something about it. So that's significant when you look at the individuals that are running these. As you heard from my mayor, she's in support of this as well, so I appreciate you guys bringing this together in order to have this heard. My recommendation is after the legislative session is we have a joint meeting, city, county, chiefs, sheriffs, and all of our legislators to be able to come together to be able to say, how can we address these issues and attack it on multiple different fronts. Thank you, gentlemen. Appreciate it.
Thank you.
George Dockstetter, South Landing Road. I see two ways that you're going to beat this horse, and one is pass a new bill, or two is initiative. I think when you guys get together and talk about this, everybody chip in $5,000, go hire the best, and I mean the best, lawyer you can find to write a new bill that will pass constitutionality and get through the state Supreme Court, and get that, and then have your town halls and get everybody behind it and flood Olympia when the bill comes up and go that route, because you're not going to beat what's already state law. They're going to keep coming at us and throwing their crap in our faces and flaunting it. And so it's going to take a little bit of money. You got plenty of towns, plenty of cities, plenty of school districts. All chip in a little bit and hire the best you can find and rewrite a new law, and then have our legislatures take it before the state. And so you don't have to sit there, well, this is unconstitutional, that won't pass, and all that crap. Get the best in the country and pay for it, and let's do it right so we can get this law changed. Thank you.
Thank you. Anyone else in the room for public comment? Anyone on the phone? Hearing, seeing none, we'll move on to update on the comprehensive plan presented by Wes McCart.
Great, thank you, Commissioners. Just a moment, we'll get it up on the screen. I'm hoping and praying my PowerPoint works here. If it doesn't, we'll improvise. There we go. Just want to kind of give you guys an update on the direction I'm headed, get any input that you might have now. Just do not head us down a wrong path, and then you guys want me to go a different direction. So thought it would be good to give you some input on the direction I am trying to take the process, working with our consultants. So first thing is just and this slide doesn't mean much, it's just my way of trying to get to the different things to show you. But what I want to show you here is just kind of the general layout of our comprehensive plan. So if I can click on this link, if it'll work for me. It won't open, so I will do what I said before, and I will improvise. This is why you bring up flash drive with all this stuff in it. So this is our current comprehensive plan, and if I can get it to slide down for me without a mouse. Not working. There we go. So let's do this. Let's do this here. There we go. So again, our current comprehensive plan, as you see, and sorry, it's not really doing a page at a time, but what I want to show you is our current comprehensive plan. I don't know why it's not letting me scroll down one at a time here. Let's see if this will do it. Okay, there we go. So we have our, I'll just take one of the elements here. So you have all this information in here. You have maps. You have all this language. This is extremely important part of the comprehensive plan. But as I move through here, I've got all these different things that are in here that are good background information that as a planner, you do not use day to day. The meat and potatoes of your plan are your goals and policies. And as you can see, now I've moved into a section where we have, oh, here we go again. Next time I do this, I bring a mouse. Why is this not going that way? There we go. So we have our goals and policies mixed in amongst the plan here. And again, it's a little hard to see as I'm scrolling, but you can see the goals. And you end up with these different goals in here mixed in with the language. So what I would like to see us do differently is I'm going to show you, and AHBL actually helped work on these plans, but and this is not the only county, but I'm most aware of Stevens County. So I'm going to open up Stevens County's plan and go through it a little bit. And when you start looking at this, you'll notice in the introduction, there's a small little paragraph there. And then, if I could scroll down on the page a little bit here, get out of that. You'll notice, if I can get it to work. So this particular volume has all the different language background in it. You'll notice there's no goals, there's no policies, nothing. In another volume, in volume 1, and this is the one we would use all the time, in volume 1, as I go through here, and I have a preamble, I have a vision statement, and then as I get to each I have a small amount of language in there, and then you'll notice in this section here that I have general goals and policies. I have the goals, and then a little bit farther down on the page, if it'll let me go that way, which it doesn't seem to want to do on this computer. Again, I apologize. This is not what I wanted to have happen. But you can see then I have general policies. So, there we go. Thank you, sir. You're a lifesaver. So this makes it a little easier. So you'll notice that I have a couple of goals that are in bullet points, and then I have my policies. These are the overarching policies that guide all the development regulations. This is where you make all of your major statements going in. But you can see as I scroll through here that I get to an economic development section. I have a little lead-in paragraph. I have I have my goals bullet pointed out, and then I end up with policies, and they're numbered. So one of the things I really like about this format is that when I ask, or anyone asks, for economic development funds, one of the things in the form that we have there is, how are you supporting this? Where is it in the economic development plan? Where is it in your comprehensive plan? That's a requirement by law. Well, look how easy it would be for me to fill that in. ED1, ED5, ED12. Those are the ones that would promote my project. I don't have to sit here and go through page after page after page of language to try and come down for a justification of why we're doing something. So this is more of just a structural change, but it's different from what we currently have. So I do want to point that out for you. Yes, sir. Go ahead.
Yes, please.
Okay.
Pretty please with a cherry on top.
Well, I can tell you that my staff would greatly appreciate doing that same thing. So if I go back to the PowerPoint now, I'll go through a few more things here. Let's go back to the presentation. So in here, again, it's just two different ways of doing things. One of the hard parts of pointing this out to you is that in previous updates, you may have seen an red line version. We're doing a crosswalk to make sure that we have a valid record of everything we're moving anywhere. But if I give you gentlemen, as well as the Planning Commission and members of the public, a red line version, it's going to be this thick, and you're going to get lost in a whole bunch of stuff you don't need. So I don't really want to give you I can give you a red line version to refer to, but I really want to give you, when we get to the point where, we're actually starting to want your detailed input on these, and we start having hearings, everything's probably going to be to you in a clean version. I'll have the red line available. Again, for the record, I need that, but I don't need to make your world more complicated than it already is.
So as long as you keep everything in less than 1.5 inch 3-ring binder, no 5-inch 3-ring binders.
I won't guarantee that, but I'll do my best.
Hey, I got to try.
So a couple things I want to add to our current comprehensive plan structure also is a preamble. Is a preamble absolutely necessary? No. But the preamble lays out, and again, we'll tailor it to Franklin County here, but it lays out the Constitution, principles of individual rights, and the purpose for planning. That's your preamble. It's like somewhat a vision statement, but it's a little more detailed. You also currently don't have any general planning policies. Now, why are these important? Well, for example, a good general policy would be to protect and maintain property rights of the citizens of the county and ensure private property is not taken or damaged. I think that's a pretty powerful statement for a policy to have in your comprehensive plan. We're putting all of the different goals of the GMA on the same level, including property rights, which a lot of times get ignored in comprehensive plans. Another is to ensure decision makers evaluate carefully the effect of their administrative, regulatory, and legislative action on constitutionally protected rights. So what does that mean? That means that I'm protecting substantive due process. And this is something I use as a guiding principle as I'm trying to come up with these documents and I'm reviewing them with the consultant. In order to regulate, I must identify the harm that I'm trying to prevent. The harm has to be real, and the regulation has to be proportional. And we should be asking that throughout this entire process. So we're trying to do this up front so that you gentlemen can look at that and say, did we do our job properly when we get to the actual pieces?
I really appreciate that. Somehow in the preamble, it needs to say that it needs to be, if we're going to regulate it, it needs to be proportional and real.
Okay.
I don't know. I got all afternoon. You want to just go for it right now? I'm kidding. I'm kidding.
Okay. One of the other things I wanted to add here is a park and recreation element. So before Commissioner Didier starts screaming at me that we're going to have all kinds of county parks that we don't need, I'm just going to jump to the quick. We already do have policies related to park and recreation. And it's not meant to function that the county is going to develop parks. Not that we won't either, but allows us to support our parks and recreation that we currently have and expand those things. We have the Juniper Dunes. We have Levy Park. These are policies that we can put in place in this section to support what we want to see as a vision for how that we would support and or regulate. In this case, probably more support than regulate. Currently, you collect parks fees in a couple different entities, and this will also allow us to come up with a mechanism to distribute those park fees to benefit our citizens here in the county. So that's why I want to add that element. Also, it doesn't make any sense to have park and rec elements stuck in like a utility section. just doesn't flow very well for the use of the citizens or the use of the planning department. The last thing we'll be adding, of course, is a mandate by state law, climate policy. We have to add the sections, we have to add climate policies under law to our comprehensive plan. And my intent is to have a climate element, but also to turn around and have, in specific parts like vehicle miles traveled, that makes more sense to have in the transportation element. So they'll be scattered throughout if they pertain specifically to that element. We are required to reduce our carbon footprint. That is one of the requirements in the law. My approach that I'm proposing for you gentlemen to adopt will be one of similar to the voluntary stewardship program, where it's voluntary, more of a voluntary action on the part of the owner of the facility or a piece of property to implement these carbon reductions, rather than a regulatory approach. I want a voluntary approach with this. Yes, sir.
Can we adopt President Trump's wordage on the climate policies as the green hoax? I would like to see that in there.
Sir, I think we could probably make a statement that's a little bit different than exactly those words, but yeah.
Thank you.
Again, I have to meet the mandates of the state law in order to keep us from having potential lawsuits or litigation, but I get the sentiment, and
Thank
it's
you.
not lost on me. So in this, again, I was going to show you in the plan, but I'll show this to the next. I'll just move to the next slide here. And I apologize. Somehow this font got changed and it's not coming up very good on my slides. But what we did is we took one section, and this is the economic development section. And we're doing this with every element in the plan. And what we did is we went through the existing goals that were there. That's in your left-hand column. That's your existing goals. And in the existing goals, we kind of looked, you'll see, some of them are similar here in this particular slide, and I'll come back to the slide in a minute. But some of these we moved to policies. So if you look at this page, maintain the Goal 11, maintain the environmental quality of life so that Franklin County is a preferred place to work and visit. I look at that and go, how's that a goal? That is not a goal of economic development. So what we did is I and my staff went through, thank you very much for having our new employee who's long-range planner, because he's doing the lion's share of the work to pull this together, and we're brainstorming to come up with the actual goals. We took like 13 goals in this section, and I think we ended up with 2. 2 goals, overarching, to get it down to exactly what it is that should be our economic development goals. And you can see they're here. They're pretty broad-based. Maintain a thriving and stable economy that supports existing industry businesses and agriculture while attracting new opportunities for economic growth and diversification. That's one goal. Very broad-based. That's the idea of a goal, to be very broad-based, right? Then what we've done is we've come down here and we now have taken and came up with the policies that are there. And in some of the policies, I'll show you one in particular, just as a piece here, or just point to it as an example. So one of the goals or policies that was in there was to support the Port District in their ability to have incubator businesses. Well, why are we picking just the port? If Tridec wants to have incubators, if personal private industry wants to have incubators to help do businesses, if it's the port, it doesn't matter who it is. Our policy shouldn't be so specific that it puts us in a box that we can't get out of. So what we've done is come up with several policies here that, well, you can see on the bottom of this slide, work with the ports of Pasco, Colotis, Benton Franklin Economic Development District, Tri-County Industrial Development District, and municipalities to identify economic development opportunities. Well, we changed that to be work with outside agencies and groups to promote economic development opportunities. If we're trying to think for 20 years in the future, these entities might not even be here 20 years from now. What if another entity gets in here? So again, we're trying to come back to have your comprehensive plan be more broad-based so that it can adapt to where we are 10, 15, 20 years down the road in our planning horizon. And it's unfortunate, in my opinion, and I probably shouldn't say this, but I'm going to say it anyway. Last time Franklin County did an update, and I've heard this multiple times by people in my office and the consultant, they were told to do a very light touch to the update. Gentlemen, I'm here to tell you that I'm not taking a light touch to the update here. This should have been done a long time ago.
The reason we took a light touch last time is because we were waiting on Wes McCart to get here.
Well, thank you, sir, but I think that's, it should have been done previously. So you can see I've got a crosswalk here for everything we've done. Again, we've tried not to leave anything out that was pertinent. When you get this clean version, it'll look similar to what I showed you in the draft I want to go to, that format. So you'll be able to read a little intro, you'll be able to read the goals, you'll be able to read down through all the different policies, move to the next section, and do exactly the same thing. And that'll make it very easy to say, hey, you guys, you missed this, or we'd like you to think about this to add. And the same for the public. Because again, all that information for housing numbers and employment numbers, it's all extremely important. And it's great to put in a different volume. But 99% of the people are never going to read it. They're never going to look at it. And this affects everybody's life every day when it's related to property. So the next thing I'm kind of come back to this mitigation map, so I can get through the rest of these power slides. Then I'll come back to the shrub step. I do want to give you a brief update on where we are for the regulations. So as the consultant we're going through the goals and policies right now, and we're shoving them to consultants. The consultants is putting in stuff that's new that they're thinking of. Try not to duplicate efforts. We're meeting with them regularly, but they've gone ahead and they've redone Title 14. So Title 14 is the administrative code. It's the overarching process for the rest of the regulations. Title, subdivisions, your zoning ordinance, your critical areas ordinance, all of that follows this path. A couple things to highlight here is, yes, we're moving to a hearing examiner. The scope of the Planning Commission will change. We're going to be restructuring appeals. Still working on this section quite a little bit. I want to get rid of any type of pre-decision appeal. I've heard that from other attorneys. I want to make sure that happens. Most appeals will be either LUPA cases. There will be a small number of appeals that will still come to the Board of County Commissioners. We don't want to completely do away with that. There are certain things that, especially if they're legislative items, should be appealed to you gentlemen before they get to the Superior Court. Permitting timelines have changed in the law. There's been a lot of bills over the last several years that have changed permitting timelines. So I want to make sure that we're consistent with our permitting guidelines. Also, our current code has appeal periods in it that are different from the appeal periods we have in the administrative code. Those types of things need to be aligned. So my understanding is I can bring Title 14 to you gentlemen at any time and have you adopt it. I can hold a hearing and we can adopt it separately than doing the rest of the plan. My conundrum in that is making sure that we're consistent. I don't want to come to you, have you go through the hearing process, do it, and then have it so far out of whack that I've got to bring it to you again when we get done.
So a question for you on this particular portion. I was a part of helping the city of Pasco go to a hearings examiner. I think it's a much better process. As we go to that, that is an expense to that. There is some efficiencies by doing it, certainly, but there's an expense there as well. How do we pay for that expense?
So, well, currently we are paying the planning commissioners to come to their meetings.
Okay.
So there is some
efficiency there.
Pieces there that are piece. We're spending time with staff to staff the planning commission. You know, we're not doing away with the planning commission, but most of the commission's work will be legislative proposals, changes to code. So a lot of times during the year, they're not needed at all. So there's very little expense in the planning commission. We can cut that down. The other is I think we save some efficiencies through your department because you're not sitting here doing the work of a hearing examiner. So, you know, is there dollar expense to a hearing examiner? The other component here in redoing the regulations is it is my intent. Currently, a majority of stuff that we do is a conditional use permit. That needs to change. The use tables that we currently have are, my word, horrific. They're horrible. They don't talk about much. They leave a lot to interpretation, which we're open to challenge for arbitrary and capricious decisions. I don't like that situation at all, to being put in that situation. When we do that, we'll have outright permitted. We'll have, which means you don't need a permit, you can just do it. You'll have an administrative conditional use permit, and you'll have a conditional use permit. The administrative conditional use permit allows us to do what we do every single day. And with the experts that we have hired that can make the decision in my office, and it's done. If it's appealed, depending on the type it would be, it might come to you gentlemen, it might go to a hearing examiner, so that's very limited. If we're doing our work right, we won't get appealed much. Conditional use permit, those probably have to have an open public hearing for those, will be conducted by a hearing examiner. So it's taken a lot of burden off of you gentlemen, as well as you know, be able to save some money on the planning commission. But I think most of what you're getting at, Commissioner Bauman, is you might end up paying in my budget on the front end for the hearing examiner. But I think on the back end, if I can pull permits through in 45 days or less for some of the permits that are going to hearing, I'm gaining efficiencies that way for the public in general. And my feeling is, shouldn't we be spending the taxpayer monies to be efficient users of those funds? Right now, just simply to get it a pre-decision recommendation from the Planning Commission to you gentlemen without an appeal takes me 5 to 6 weeks, just merely the timing. That's money in someone else's pocket that's not coming into general, helping the citizens make money that we then benefit from.
So John Q. Public walks in the door and makes application today versus under a hearings examiner. Does John Q. Public's application cost different more or less as far as using the hearings examiner versus the planning commission process?
Probably not a whole lot, because I probably have less staff time and more hearing examiner.
Yep, that was my.
So I would think that I'm probably not overall going to change the cost of the permits whatsoever related to the one process versus the other. But I will tell you that the process we currently have, and one of the things I struggle with as your director, bringing things to you gentlemen to hear right now, is I've got applications that are waiting to be heard by the planning commission. I've got applications that are waiting to be heard for you gentlemen. I've got ones that are in the door, and I've got ones that are way over here that are ready to get out the door. And keeping that all aligned is difficult. Those timelines are very difficult to run. So, go ahead, sir.
Oh, I'm looking forward to the next step in this process. I am in favor of passing Title 14 as soon as you can get it assembled and prepared for us. I'm in favor of that, and thank you for the cleaning things up. As somebody that is in the development world, I can appreciate Utopia. I've never been there, I've never seen it, but I have written or I have read a lot of different policies and procedures that describe Utopia, except for it just doesn't work. And I appreciate you taking 36 different goals and objectives and narrowing it down to a concise manner. And I believe the efficiency that we will see is about a third, going from the planning commission process to a hearings examiner. And I know that will be appreciated by the people that use our services. And I'm looking forward to supporting you in whatever way I can and getting this process moved along.
Great. Thank you.
I don't want to confuse Utopia with Eltopia, two different places.
Yeah, so...
Eltopia is...
Let's see. I heard one time a commissioner say it was hell to pay. Right now we're
right off the rails.
So, realistically, I really would love to bring you Title 14 sooner rather than later. Again, I think one of my hesitations is I'm not quite done with it. I want to make sure that I'm crosswalking the use tables a little bit more efficiently. I need probably to check with Jeff on making sure that I am appropriately pretty much laying out language that protects us so that we don't get gummed up until we get 16, 17 updated. That if there's a timeline difference, I have the right verbiage in it that it would supersede. Again, one of the common things I have right now is in appeals. Specific appeals have a timeline of you have to file the appeal in 10 days in this section, and it's 14 days in the other section, and then I'm relying on the piece that I have to use the most restrictive, which in an appeal would be the longest timeline. So trying to get that language right, so that again I'm not trying to bring it back to you and do it again, would be my my due diligence before I bring it.
Right, and if I could add something there, like when you're putting in a whole new title, a whole new section of the code, that's one of the principal things that I'm trying to look for is you've got to kind of know your own code pretty well, and we think some of these inconsistencies in our code was caused by just that, by someone looking sort of myopically narrowly at this one section of code and not understanding we have appeal procedures in several different sections, and why is it not more readable? I understand it's code and it's not exactly a page turner, but it shouldn't be internally inconsistent. And so I mean I think we can do better in terms of making it more so we're not scratching our heads. Of all people, we should know what our code means, and we're having debates about what the language means. So
So Wes, something I don't want to forget that just, you know this already, but to make my fellow commissioners aware of it, last week at Wasac, I spoke to one of our fellow commissioners from Skagit County, and the city of Seattle has purchased 17,000 acres of land in Skagit, have taken it off of the tax rolls, and they have put it into conservation in perpetuity. And to take that many acres out of production forever and it become a burden. You still have to manage, but you have less opportunity for return. Just want to be aware of that as we are working on our comp plan. I'm not sure exactly how we say that, but to take 17,000 acres out of potential production is not productive.
Yeah, I can put that into terminology that will be in the plan that to achieve what you want, and it's a great lead-in. So, Commissioner Bauman, you've been, I've been in several meetings with you for Shrub Step, and I know this is not Franklin County, this is Benton County, but this is something we're working on regionally. I'm using the same consultant. You guys did approve hiring this consultant. I did want to spend just a minute and show you kind of the product that I'm hoping to gain out of this. And again, this is a regional conversation. So this is kind of just a rough Shrub Step map. If I move to the next map here, you'll see this is the WSRI map. So this is different species map. So these, and then I move to a biodiversity map. That's page 3 that you were given. And you can see the different colors there that range to biodiversity. And what I really want to get to is that my consultants that we hired for doing this is the end product that we'll be getting. So they take those 3 maps, they pull them together, they take other outside information that's best available science, and we get this map here, which if I go up to the corner up here, you'll see that it produces what I'm going to call a matrix map. And on the lower left-hand corner where it says low, low, that means the quality of Shrub Step that's there, that yes, it does meet the definition, and we actually will have a definition of Shrub Step, meets the definition of Shrub Step. But it's extremely low quality. And as you move to the up, straight up, it gets a little higher. If you move straight over, it gets a little higher. And when you get to that very top right-hand corner, that is very high quality Shrub Step habitat. And one of the things I really want to point out to you gentlemen in what we're required to do here in the Critical Areas Ordinance is I'm required to protect the habitat, but I'm required to protect the habitat for the critters that live there, not for the habitat itself. If I don't have good habitat, I don't have the critters, which is what I'm trying to get to. I'm trying to save the birds and the animals and the different folks that use the Shrub Step habitat, not the habitat just for habitat's sake. So what this will allow us to do is have a broader conversation with the WDFW. And I was warned by the consultant that the conversation that they're currently having is mitigation anywhere from an 8-to-1 all the way down to, no mitigation required. Well, that's pretty arbitrary and capricious at this point, because even the conversations that Commissioner Bauman and I have been in previously, their comments were 2-to-1. So now all of a sudden, where the heck are you coming up with 8? The other that this is going to allow us to do is the emphasis will be exactly what you were pointing out earlier. And that's not on buying land to set aside forever that gets taken off the rolls. But aren't we a whole lot better off if we improve the habitat we currently have? Having a whole lot, if Franklin County was horrible habitat, we wouldn't have a whole lot of critters here. Why aren't we improving the habitat that we do have, and we'll have a whole lot of critters here that will coexist with what we're doing now? That's the end goal, not to buy land to put it off to its side. And the mitigation needs to be scientifically based in those conversations with the department. And I think you gentlemen all know me well enough to know that I'm not afraid to stand in the corner and fight an agency.
So I appreciate that, Wes. So for you commissioners, we have in Franklin County, we have a wildlife management unit area called I think it's called Big Flat. And so in one of the meetings that Wes and I was in, I asked the question is, instead of mitigating just space for space, can we mitigate and go to a place such as Big Flat HMU and make the habitat there better instead of going and putting a bigger footprint down? So increase what already is set aside instead of just setting more aside, because there's, in one of our meetings, there was somebody said that it was a regional meeting, and somebody said that they had been approached by private equity. I've said this in one of our meetings before, but private equity had approached and said they had up to $100 million to put together a land bank, and that scares me, to go take a lot of farm ground out of production. So thank you. Just wanted to say that out loud.
Well, in our conversations with the Conservation District, I've been having a lot of conversation with the Conservation District, and they're of the same mindset. There may be some land that gets set aside for a bank somewhere. We're talking small amount of land. Maybe it's not very good land that we take and we can improve, but there's so much room. I mean, the main reason we have conservation districts is to conserve the land. They're good at doing this. Okay, you're a developer, you want to do something. I have a, 1.2 to 1 mitigation ratio that you have to do. We come up with, what does that look like as far as planting some sage in some areas that, used to have sage that was burned, or, that just has a lot of rabbit brush and it doesn't have any sage with it. So a lot of plantings and stuff that we can do to get the mitigation to improve that habitat versus, again, putting land off to the side. And they're on board with this program. So,
yeah. And I appreciate that. Our job as commissioners is to report to the public that we serve, and one of the components of that is telling this story that, in an understandable fashion. We've all seen the boat docks, the private boat docks on the Franklin County side of the river that have gone in over the last 25 years. And some of the mitigation that was required of some of those boat docks was that they go out to the east end of Findlay and go out there and plant some different vegetations and then maintain it for 2 years. And you had to document that you were taking care of it, and in some cases, when you were in hot summer, you had to carry water out there with your car, clear out to the far reaches of the east end of Findlay, and you had to do that every other day during the hot summertime for 2 years in order to make sure your mitigation plants were viable and growing on their own. And there's just some of the levels of ridiculousness that we go to in one way could be taken care of much simpler and much more effectively in another. So just wanted to say that out loud.
So that's kind of the end of my presentation. If you have any questions or
Chairman.
anything you want to see, please,
Chair
by all
recognizes
means.
Commissioner Didier.
Yeah, Wes, when you first came in here, we were on break, and I stepped by you, and I said, so Wes, under what title can we address this EPA on the secure community transition facilities? Where would that fall underneath which title?
So, probably under a couple different titles, probably 16 and 17. So some of it could be zoning, some of it could be development regulations. So I don't know if you gentlemen are aware of this, but there was a huge facility that was proposed to go into Chewelah. So at this whole conversation of mental health facilities, these secure transition facilities, these homes, this is not new to me in any way.
Right.
And I even met with the city of Colville and met with their city council and gave them some suggestions on which direction they should go. So essential public facilities right now, we by law cannot prohibit their location. However, by law, we can also condition their location or point out the locations they should go. So one of it's a zoning exercise in where do we properly allow these facilities to be sited. And a lot of these facilities require a certain amount of infrastructure, water and sewer. So, our most vulnerabilities right now for having these facilities come into the county are in the cities. That's the highest priority. But if you look at the donut holes we have in the city of Pasco and the urban growth area, if it's served by water and sewer, there's a chance they could come in there. So part of it is, do we zone these to be in a more appropriate location? So that's one tact that you can take. The other is you can put provisions in your code that are required to go with these facilities. Security. You can require lighting. You can require perhaps sidewalk. There's all these different things that you can require in your code that be available when these things are being cited. So it doesn't prohibit it, but we can't limit it to the spot where it wouldn't be possible to put one in the county, but we can also put reasonable controls on it so that, you have, one of the things we're proposing in Chewelah when that facility was going on, had they done it previously and they're putting in the code now, is to require security. If you're going to put a facility in like this, you have to have some type of security guard type system, and you have to have the right kind of lighting. That type of thing, again, will it prevent everything from happening? No, bad people do bad things. So, so that's kind of the tact that I would suggest we take at this point from a local level in a regulatory framework. But I agree with what was said earlier. This needs to change. Why these facilities are in code as essential public facilities in the law, it's beyond me. It's just because they're hard to cite and the state doesn't want to take time to figure out how to put them somewhere. My 2 cents.
Thank you. Right. Thank you, Wes.
So any other questions? Any other comments? If you gentlemen have anything you want to see in the updated code, the sooner you can tell me, the better. I'm happy to take all suggestions. I'd like to do this once and have it look good for the next couple of decades.
Well, I think you're well on your way. I think we're all in favor of the acronym KISS. Keep it simple.
I would I agree with that wholeheartedly. And I can't remember the articulation of it, but if you're going to regulate, you got to have justification. And if you're going to, it has to be proportional. And with that being your guiding principle to the construction of this document, this isn't difficult. My guess is you're going to reduce the volume of the document by probably half or more, making it simple. With that being the guiding principle that you craft this with, I'm looking forward to seeing it.
Thanks, Wes.
Okay,
I
thank you.
appreciate it. And Mr. Danzel? Just wanted to point out that Wes is still navigating a complex lane that he is trying to do his best with, as Jeff said, as Council Briggs said, some of our code conflicts with itself. Some of it's hard to read. Some of it we don't even agree on internally. And so one of the things that I want to thank Wes for was the fortitude and the patience, because anytime you initially inherit something that needs that much work, there's going to be some transition time that isn't real pleasant. But I appreciate you always being very communicative to not only myself and the board, but to the members of the public at large about what your efforts are. So thank you very much, sir.
Yes, thank you, Wes, and whatever it takes to get that process going smoother and faster. Appreciate.
You sound like my wife when I was building my house. I'd ask her a question and she says, bigger, cheaper. So.
Well, we just got to make sure the process is faster and fair and that our community can get their permits quicker. So, thank you. With that is public comment on workshop items only. If there anyone in the room that wants to comment on public comment.
I appreciate what Wes is doing. The only question I've got about that was the one name I saw on there, Nicole Stickney from AHBL. When we were doing the comprehensive plan last time for the city, she had a tendency to cave to everything future-wise, wanted to do real quick and go with what they wanted instead of what the community wanted. So I'd advise you not so much on redrafting the plan like that, but when we get down to the details on zoning and whatnot, to be careful. Thank you.
Thank you. Anyone else in the room for public comment? Anyone on the phone? Hearing, seeing none, we will move on to executive session. Who do you want present and for how long?
The board will need county administrator, clerk of the board, Ms. Lloyd, 15 minutes, RCW 4230-110-1I.
Yeah, I would like to do a closed session. I can address some of my things in executive session. One would have to be in closed session, the other can address in executive session.
Thank you, Wes.
I think technically we'd have to come out and adjourn the meeting to talk
Keep it
about
going, Wes.
closed session.
Thank you.
Have you guys been out to see the golf course out there?
much longer do you think we need?
I need to walk, because I can get stiff. 10 for 15, is that what we're doing?
10. I got doctor's appointment at 5. We've come out of executive session with no decisions being made. We're going to go back into executive session under the same RCW code for approximately 10 minutes, for 10 minutes. So the time is 12:45. We'll be back at 12:55.
thought this was all gonna.
It's already
be
1 o'clock.
4 hours or sooner.
We've come out of executive session with no decisions being made. We are going to go back into executive session for another 5 minutes. The time is 12:59, so we'll be back at 1:04. Same RCW code.
All right, so there was,
Not yet.
Take it away, Mr. Chairman.
We've come out of executive session with no decisions being made. Is there any other business for the good of the county?
Yes, Mr. Chairman, there is. I would move that we would amend the agenda to add a potential action item to the agenda.
I second.
Motion and a second. All in favor signify by saying aye.
Aye.
Aye. Motion passes
Aye.
unanimously.
And with that, Mr. Chairman, I would move that we would authorize our county administrator, along with our legal counsel, to negotiate with Benton County on an adjusted agreement for the termination of our juvenile housing with Benton County.
I second.
Motion and a second. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Aye. Motion passes unanimously.
So, Mr. Chairman, just as we close out our meeting, I just have a request. I think that with where we're at, with all of the work that's happening here in Franklin County, with our preparation for taking on human services, with all of its complexities and oversight needed, taking on veteran services, I would like to see our administrator, along with our HR director, prepare for us a proposed new position within the Commissioner's office, and that is a position of Deputy County Administrator. And would like to see that happen and be prepared for us for next week if you're able.
Was that a motion?
Yes.
Second.
Motion and a second. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Aye. Motion passes unanimously.
Mr. Chairman?
Yes.
With the, our administrator and our legal going to meet with Benton County again, may I ask that this time they bring us a signed agreement so Benton County can't readjust again, because we signed their last agreement and now it's not good enough for them.
Yes, sir. We will ask for that. Thank you.
All right. Thank you. Any other business for the good of the county? Hearing none, this meeting is adjourned. We'll now go into closed session.